Good morning, Mr. Slager. Good morning, everybody.
Morning, Chairperson.
Yes, I'm dealing with the ESCOM application for leave to cross-examine Mr. Koko first, who appears for ESCOM.
Yes, they are here.
Hey, switch on your mic. Yes. Somebody will assist you. Yes, if it's, you can address me seated if that's more convenient there because of the mic.
Chair, Chris McConaughey appearing for ESCOM. My
Yes.
leader, Mr. Ngukatobi, is currently acting in the Eastern Cape. But
Yes.
I've been assigned to do today's application.
No, that's fine. Thank you. Mr. Berry, you appear for Mr. Koko?
Yes, sir.
I must say that I didn't come across any opposing papers for Mr. Koko, and I don't see them here. What is the position, Mr. Berry?
Those papers were filed long ago. They were made available to the Commission again today, this week rather. And I received a document this morning from Ms. van Vieren, which purported to be the paginated bundle, but I didn't check that to see whether all the papers are in there, including
Yes. Well,
Mr. Koko's opposing affidavit and ESCOM's reply.
I was given the impression maybe a day or two ago that Mr. Koko was opposing and that there may have been papers, but I see that they are not here.
The bundle that I received this morning
has got them. Mr. Salega?
the bundle that I received this morning has Mr. Koko's affidavit from page 110.
Mr. Salega?
Thank you, Chair.
What's the story?
There is a bundle prepared, Chair, on page...
The one I've got here doesn't have opposing papers.
Chair, please check page 110. 110. I see they did the red pagination.
Oh, okay.
Yes.
But there is... Oh, okay, no, I see there is in this file, but I haven't had a chance to read it, but I think, let's see how it goes. Let me hear the legal representative for ESCOM first.
Thank you, Chair.
Let him go to the podium. Please just repeat your name so I can make sure I've got it right.
Thank you, Chairperson. It is Chris McConaughey of the Johannesburg Bar for ESCOM. And
That is, how do you spell McConaughey?
it is MCC,
Capital letter C, the second one?
capital letter C, that's correct, Chair.
Yes.
ONN,
I'm sorry?
ONN,
ONN
ACH.
ONNSCH.
Sorry, Chair, A for Apple, ACHIE.
McConaughey.
McConaughey, that's correct, Chair.
Okay. Is it
Chair,
she
if it-
or key?
Key.
Okay, all right.
There's a long history, Chair.
Okay.
Chair, if it would assist, we've prepared a short note for argument, which, apart from setting out the correct spelling of the surnames, also includes a brief synopsis of the case, which might
Okay,
also assist.
let me
if I could
have
beg leave
that.
to hand up.
Yeah. I'm sure everybody was given an indication that I didn't think we should take too long on the matter.
Indeed, Chair.
Thank you.
And we hope the note for argument will expedite things. I certainly don't intend to read or to take you through it in any detail, but it's designed to simply capture the key crisp points
Yes.
and also to summarize the essence of the application.
Yeah, I'll tell you what my concerns are, because if you persuade me on those concerns, then I would hear what Mr. Berry has to say. I don't know whether Mr. Selega intends saying anything, and then we'll take it from there. As I understand ESCOM's application, basically they are concerned that Mr. Gogo has given the impression or given evidence to the effect, or that suggests that they had no proper grounds for taking disciplinary action against him. That seems to be the main thing. Am I correct?
Chairperson, it might assist if I start by dealing with those accusations that have implicated ESCOM, and there are two parts to that.
Yeah, but I want to characterize the basis first. Is that correct? That's the main basis.
That's the first basis, Chair.
Yeah,
There's
what is the other one?
There's
Yeah,
the second,
what is the
and
second
perhaps even more critical,
Yeah, which
is
one
the
is that?
allegation that's repeatedly been made by Mr. Koko in his affidavit and in all the 9 hearings,
Yes.
that ESCOM misled the High Court regarding Mr. Koko's role in the McKinsey MSA transaction.
Yes, yes.
And the various imputations that he's made of dishonesty against ESCOM. 3 judges of the full court
Yeah.
in Pretoria,
Yeah.
who Mr. Koko suggests were part of what he's colourfully termed the Koko hunt.
Yeah. Okay, no, that's fine. To a very large extent, that doesn't disturb the concern I want to put to you. And that concern is this, that when the person who is applying for leave to cross-examine complains that a witness has implicated them in corruption or state capture, that's an easier application to grant. This one doesn't appear to fall within that, as I see, within that category, as I see it. This one seems to revolve around saying, in effect, what this witness has said about us is factually not true, or is just not justified by the evidence, Now, my inclination with regard to matters such as that is to say, this is an inquiry. You've got evidence leaders who lead the evidence and who act or perform their duties in terms of, among others, rules that say they need to question witnesses with a view to establishing the truth. In those circumstances, and more so, of course, with where we are now in terms of trying to wrap up the evidence, there may be difficulty in seeing why it's in the interest of the work of the Commission, and of course, that's what the rules say, why it's in the interest of the work of the Commission to grant leave to cross-examine. Mr. Koko is one of those witnesses who has appeared here many times and has been questioned for a long time by the evidence leader of the relevant work stream. Of course, the inquiry functions on the basis that if, for example, an employee of ESCOM, official of ESCOM, or former official of ESCOM is before the Commission and gives certain evidence, ESCOM is entitled, if it thinks that the evidence is not correct, to place or give the Commission evidence that will give the correct picture so that the witness can be questioned on the strength of all the evidence. But also, ESCOM would say, well, or could have said, well, if this witness of ours hasn't been led, we suggest that this witness be led because he or she will then be able to put the correct picture. So my inclination with this category is that I would struggle to conclude that it's in the interest of the work of the Commission to grant leave. So that's what I wanted to put to you, but you can address me.
Thank you, Chairperson. I appreciate that steer on your concerns.
Yes,
I intend to address those concerns directly in three parts with your leave, Chair.
Yes.
The first is that very important concern about the allegations that Mr. Koko has made and whether ESCOM could truly be categorized as an implicated party in terms of the rules, which I believe would be your first concern, Chair.
Yes.
The second concern then relates to the proposed line of cross-examination that ESCOM proposes to address those allegations. And the third link to that is why that line of cross-examination would be assisting the Commission in wrapping up its work and be in the best interest of the Commission. So, Chair, and in the course of that, I hope I would address the concerns.
Yes.
If I may start then, Chair, with that very first point that you raised with me, and that is the question of the allegations, the implications. Chair, we've summarized those allegations again for your reference at page 4 of the note that I handed up and onwards.
Yes.
And I don't intend to take you through in any detail through the various allegations that Mr. Koko made in his affidavits and before in this hearing.
Yes.
But I think the pertinent point you put to me, Chair, is how does that implicate ESCOM?
That's right, yes.
And if I may start with the first allegation that Mr. Koko raised.
And the implication might not just be implication, but implication in the kinds of allegations that the Commission is investigating.
Indeed, Chair. Indeed.
Because otherwise, if it's just some implication that doesn't fall within what we are investigating, there might be a problem too.
Indeed, Chairperson.
Yeah. Okay.
If I may start with that first allegation. Chair, you'll recall that Mr. Koko, in his evidence on 3 December, suggested that ESCOM had fabricated the disciplinary charges that he had faced in January of 2018. And he made the pertinent allegation that they had fabricated these on the instructions of the then Deputy President. And the suggestion was, in essence, Chair, one of almost reverse state capture, a form of interference in ESCOM's functions, which resulted in Mr. Koko's words, a baseless set of disciplinary charges that were put to him in January of 2018. Those are the disciplinary charges, Chair, that Mr. Koko, in the course of his disciplinary hearing in February of 2018, he resigned 30 minutes into that hearing rather than answering to those charges. But nevertheless, he's used these proceedings to perpetuate this narrative that those charges were baseless and had no substance, even though he, in essence, ran away from those charges, Chair.
Of course, it's not unreasonable to think that a bystander could well think that he was running away from facing those charges, which would not be consistent with any allegation that those charges were without foundation.
Yes, indeed, Chair. But he's used these proceedings to, of course, attempt to present a different narrative that he...
No, I understand that, but what I'm saying is that mere point could well send a message to the public that doesn't support any allegation that ESCOM had brought baseless charges against him. Because if they were baseless, why didn't he meet them head on?
Indeed, Chair. We would hope that that would be the reasonable inference that someone would draw. But the implication that Mr. Koko and the allegation he's continued to make is to say that...
Of course, you may appreciate why it's relevant for me to raise that.
Indeed,
that is
Chair.
simply because it may dilute the strength of your case insofar as you say, this person says we brought baseless charges against him. So insofar as it goes to that, you have a situation where by his conduct, the public might not, or at least some of the public might, part of the public might not believe that.
Chair, that is the inference we would hope would be drawn, but
Yes.
of course Mr. Koko has presented a very different version in front
Yeah.
of this commission.
Yes.
And it goes to the point of implication, because Mr. Koko has in essence inferred that the board of ESCOM breached its fiduciary duties by putting together trumped-up charges based on external interference, which of course, Chair, is a very serious criminal offence that goes to PFMA obligations of the board, its fiduciary obligations, which are backed up by criminal sanctions. We would suggest to the Chair that certainly is an allegation which is very much at the heart of the Commission's work. And indeed, part of course, the Commission's role is not only to address that maladministration that has occurred, but also to support efforts to uncover maladministration. And indeed, Mr. Koko's allegations call into question those efforts. But Chair, the second and more important allegation which Mr. Koko has made is, as I mentioned initially, the persistent allegation that ESCOM misled the High Court, and that the High Court itself was misled regarding Mr. Koko's role in the Master Services Agreement. And that's a thread that runs between the first and second allegations. Mr. Koko, of course, tells the Commission repeatedly that he had nothing to do with the Master Services Agreement. In his own words, he said he had zero role whatsoever. And he also denies any involvement in facilitating that agreement, its settlement, or the 1.6 billion rand that was ultimately paid out unlawfully to McKinsey and Trillion. But Chair, Mr. Koko has in his affidavit initially told the court to quote, and this is his original affidavit to the Commission, paragraph 230, he says, quote, ESCOM clearly did not make proper honest disclosure to the court. But in his submissions to the court, to the Commission rather, on 3 December, he went further to then make very serious allegations against the court itself. Where, Chair, on 3 December, Mr. Koko, it's a long passage which I won't give to the court, but we summarize it at page 6 of the note. In essence, again to quote, says, the members of the court, the full bench, was caught in the state capture theory, which was his quote. In subsequent proceedings, he's doubled down on those allegations, Chair. He's gone on to, and this is a quote taken from his proceedings on the 4th of May this year, which we've quoted at page 7, paragraph 12.7. He suggests, and I again quote, and I think the gossipers and the people that are on the Koko hunt missed it, the various allegations, including your colleagues at the Pretoria High Court, which is one of the very painful things to me because they've concluded there was a corrupt relationship. And I'm saying to you, if they had regard to the evidence that you now have, they would have reached a different conclusion. So, Chairperson, there are two very serious allegations combined in there. The first is one that says ESCOM, in its efforts to address maladministration and corruption, has in effect committed grave breaches of its duties, it's lied to the courts, and Mr. Koko seeks to exonerate himself. But he also then makes very serious attacks on the integrity of the judicial process and the courts themselves.
You see, insofar as the basis for Eskom's application is this man has said we have behaved badly. You know, I don't see why it's not enough to leave it to the evidence leaders to put the correct picture to the public. You see, whatever bad conduct it is, if it's not corruption, state capture, fraud, you know. So, because imagine if over the past 3 years, I was granting applications where that's the complaint, how many people would have occupied the time of the commission, you know. So that's my difficulty, where you are not implicated in acts of state capture, corruption, and fraud, because I think primarily the rules seek to afford that category of people, you know, this opportunity of cross-examination. It may be that technically it's not like that, but in the end, when one considers the interests of the function of the commission, the work of the commission, it seems to me that it's reasonable to say, look, as far as possible, if your complaint is simply that somebody has said you have lied about them, that kind of thing, that should be sufficiently taken care of by the fact that there are evidence leaders of the commission who, in terms of the rules, are directed to question witnesses with a view to establishing the truth. You know, so that would be my inclination. Okay.
If I could give two responses, Chairperson. The first response is that these allegations we would submit do amount to a form of allegations of state capture. The first allegation is that Eskom put together trumped-up charges on the basis of purely external political interference. And the second is that Mr. Koko is the victim of a grand conspiracy, a conspiracy hunt, where he has been maligned, and in fact Eskom has misled the courts about his role in state capture. So, Chair, we would submit that both of those are, again, accusations leveled at the Eskom board and the Eskom directors, which suggest grave breaches of fiduciary duties, which of course go to the very core of this Commission's function, around the proper functioning of state, organs of state, parastatals, and ensuring that maladministration and corruption is adequately addressed and nipped in the bud. But, Chair, the second point, and the question you've put to me, a very important question, is it not enough that the evidence leaders have led the evidence? And that brings me to the second topic which I intended to address, and that is the line of cross-examination Eskom proposes. Because, of course, Chair, we do not for one moment seek to undermine or criticize the evidence leaders for the manner in which they've presented the evidence before the Commission. Eskom's line of cross-examination is instead aimed to build upon and to complement the line of examination that Mr. Seleka and others have already presented. But what we suggest, Chair, is that there are two important gaps which would be important for the Commission to fill and to at least have a proper version in front of the Commission. The first, of course, Chair, is that none of those very serious allegations that I've addressed have encountered any response, a forthright response thus far. Mr. Koko has had 9 separate occasions in front of the Commission where he has voiced these allegations. They've all been left in the air, which of course leaves a significant taint both on Eskom and on the integrity of the judicial process that Eskom pursued. But, Chairperson, the second part we would suggest is that what is underlying all of Mr. Koko's allegations against Eskom is his persistent allegation that he had no role to play in the master services agreement and the unlawful payments that flowed from that. And that is what we propose would be the crisp focus of Eskom's line of intended and proposed cross-examination?
Of course, that's one of the things that are at the heart of what one of the features of what the Commission is looking into in relation to Eskom. And of course, he has been questioned quite extensively on that.
Indeed, Chairperson.
It might not be to your liking or your client's liking, but he has been questioned, and the questioning, as I understand it, he may still be required to file. He might still be sent written questions and file written answers under affidavit, but that has received quite some time has been devoted to that, isn't it?
Chair, we addressed that point at page 8 and 9 of the note, and indeed we could not suggest that Mr. Seleka has not addressed Mr. Koko's role, and he's indeed put questions to Mr. Koko related to that role. But what we suggest, Chair, is we've listened very carefully to the questions and Mr. Koko's answers. We've studied the transcripts, but we submit that there are additional lines of questioning which would be important to pursue to ensure that Mr. Koko is put to the sword, in essence, and to commit to a version. Because Mr. Seleka has, of course, elicited some very telling responses from Mr. Koko, but there are a number of loose threads connected to three main topics, Chair. That is Mr. Koko's initial role in the negotiations, his role in the settlement process, and his role in the payments. And we've outlined, Chair, a couple of illustrative points where we submit that there is need for a focused cross-examination of Mr. Koko.
Yes.
In a way which, of course, Mr. Seleka, as an evidence leader, would not be able to delve into that.
I don't want to duplicate that. I don't want to duplicate that.
I certainly won't. But, if I could give you one example, Chair, as an illustration of where we believe that Mr. Koko needs to be...
Well, maybe don't give it to me, but I can tell you that you are most welcome to approach Mr. Seleka and make suggestions of areas where you think as Eskom would like him to consider, to say we would like to consider the following, but that won't, I don't think that would be good enough to grant leave. To provide responses by way of affidavit, so that could be taken care of. Obviously, it's not the same as questioning and when a witness is on the witness stand, but this is a commission of inquiry. It's not litigation, so some of the things one has got to balance a lot of factors. But I've given you, I think,
Indeed,
more than enough time.
And if I may just conclude by briefly addressing that last point, Chair, why it would be in the Commission's best interests. And that comes to the nub of it, that Eskom proposes a crisp, focused set of cross-examination of no more than 3 hours, which would be led by Mr. Nkotobi, who is steeped in the facts. He was briefed for Mr. Koko's disciplinary inquiry. He was also the lead counsel in Eskom's review application to set aside the MSA and various other contracts. And the proposal is that because Mr. Ngqukutobi is so deeply steeped in the matter, he could render great assistance to the Commission by focusing on those final loose threads, putting it to Mr. Koko, and for once and for all, getting rid of the incredibly negative aspersions that Mr. Koko has cast, not only on Eskom, but also on the judiciary. And we would hope, Chairperson, that after Mr. Koko's 9 separate appearances, 3 hours would certainly be enough, and it would be more than just in the circumstances to allow Eskom to assist the Commission to finally put to bed Mr. Koko's very, very serious allegations. Chair, we would also suggest that, of course, we understand that there will be opportunity for further written questions to be put to Mr. Koko. But we would submit, Chair, that a witness cannot come and both seek to exonerate himself, which goes to the core of the functions of the Commission, but in doing so, issue very serious allegations of state capture and unlawfulness, and indeed criminal offences against those who have sought to bring him to book and to ensure that he's held accountable for his actions. So, Chair, in those circumstances, we submit there would be of great assistance to the Commission to make those focused submissions. And, of course, it would be a complement to written questions that might be put to Mr. Koko. But 3 hours we would submit, presented by a senior counsel who has for years been up close to these matters, would be of great assistance to the Commission in concluding its work. So, Chair, those are our submissions. I'll listen carefully to Mr. Barry, and if needs be, I would ask leave for a very brief reply, if that would be in order.
You might not get a chance to reply.
It is in your hands, Chairperson.
Yes. We have got to use the time that we have properly. I'd hope that we would finish at about 20 past. We have gone beyond that, but because I am clear in my mind, I won't need to hear any further argument. The application is dismissed. I won't give reasons, but if they are asked for, I will grant them. I will give them. Thank you. Thank you. Thank you, Mr. Makunat. Thank you.
Thank you, Chair. I will then be excused.
You
I
are
suppose, Chair.
excused.
Thank you.
Yeah, you're excused.
Thank you.
Okay. Mr. Berry, you are excused as well.
Thank you, Mr. Chairman.
Thank you.
And we will, in due course,
Thank you.
submit the written responses to what has been put to us by Mr. Seleka, I think also during the past week.
Okay, no, that's fine.
I think we committed ourselves to the 10th of June for that purpose, and we will do our best to comply with that. Thank you, sir.
Okay, thank you. Thank you. Mr. Maybeck, do you need me to adjourn a bit for 5 minutes?
Yes, please,
Yes.
Chairperson.
Okay, I'll adjourn for 10 minutes so that we can start with the day's witness. We adjourn.
Oh,
kan nie? Sê wie?
Good morning, Mr. Mybeck. Good morning, everybody.
Morning, Chairperson.
Good morning. I had hoped we were going to start earlier. I'm sorry that it didn't happen. Thank you. Mr. Singh, good morning to you. The oath you took yesterday will continue to apply today.
That's fine, sir.
Okay, thank you.
Thank you, Chairperson.
Let's continue. Yes.
Mr. Singh, could I ask you please to go to bundle 5B, your exhibit, and to turn up page 1039.
Yes,
You
sir.
recall that you asked yesterday for an opportunity to reflect on this memorandum
Yes, sir.
overnight.
That is good.
You have an opportunity to do that,
Yes, sir.
right? Please go ahead.
Sir,
Please go ahead.
Would,
I'd asked you specific questions that
Oh,
you
yes,
held
indeed.
over.
okay, in terms of, if I recall correctly, you wanted me to respond to the fact that this was a new procurement event. That's correct?
I wanted you, yes, that was amongst the questions. But you can address that.
I don't know whether it's all of us, but it seems that nobody is as audible as they ought to be, at least to me. Maybe you are saying the same about me. I don't know, maybe
No, I can hear you, sir.
go closer to the mic, I don't know, but it just seems it's not as audible as it should be. Maybe the technicians can attend to it. Okay, Mr. Mybeck.
Thank you. Yes, Mr. Singh, that is amongst one of the things that I wanted you to consider. Please go ahead.
So, Mr. Chair, in terms of it being a new procurement event, Mr. Chair, as you would see, this has been contemplated as a contract extension to the previous contract that, or to the contract that we had with regiments. So in that vein, Mr. Chair, it seems not to be a new procurement event. As I explained yesterday, it was, there were two streams. There was a advisory stream that the cross-currency swaps, and then there was a advisory stream that provided advice on the actual raising of the funding with China Development Bank in terms of reducing the cost of funding and reducing the cost of the cross-currency swap. So it was advisory in nature.
So, as I understand it, they executed this fundraising task, is that right?
Well, as I said yesterday, Mr. Chair, it was not executed by them. The counterparties to the actual transactions would have been JP Morgan and would have been China Development Bank. But what they did do was provide advisory services in terms of reducing the cost of funding relating to the cost associated with the China Development Bank loan and the cross-currency swaps that were eventually executed with JP Morgan. And that is outlined in the document, Mr. Chair. If you would like me to take you to
Well,
that, I could.
let us go, if we may. So now you've told us they provided advisory services in reducing costs. Would you can keep that page open, but can I ask you, please, to go to EB3A. I remember earlier in your evidence on this issue, you referred to MSM 177. That's the letter of the 20th of January where you made handwritten notes were affected on it. Do you recall
Yes,
that?
yes.
Please would you turn up 177 MSM?
17.
177. You indicated to us yesterday that the effect of the handwritten annotations at 180 was that fundraising was excluded from this contract. Is that correct?
That's correct.
So let us just see what it is that regiments were to do, having taken over from Nedbank. Would you go to 179 at paragraph 235? Amongst the deliverables was at 235, evaluating all potential funding sources and mechanisms to select the most appropriate avenues to pursue and execute. Is that correct?
Sorry, that's it.
235. So their job as an advisor, having taken over from Nedbank, was to evaluate all potential funding sources and mechanisms to select the most appropriate avenue to pursue and execute.
And that is correct. Evaluation would probably be in where they would look at what was available and select.
And 236, assist in the preparation and management of capital raising related tenders, RFPs, RFIs, correct?
That's correct.
And at sub 3, participate in the negotiation of commercial terms of funding from the shortlisted funders.
That is
Is that correct?
that is.
Singh fading away.
I said that is correct, sir.
Right. Now, what we do know is that they were allowed to work on this project for about 12 months without a contract that you've accepted.
Sorry, sir.
They were allowed to work on the task for 12 months without a contract. And one was put in place, or an extension was put in place ex post facto, correct?
Yes, sir.
And can we deal with the question of whether you were under any legal obligation to pay them this success?
Mr. Chair, in terms of the document that we, well, in terms of the arrangement that we had with Regiment Time, this was part of the original scope of work. As I said, it was de-scoped during this period of time as when this LOI was signed, with, due to the fact that it was not appropriate for them to engage in this type of activity at the time. But it was always an understanding that they were going to be able to assist in the execution of the funding. So from that perspective, there was an understanding.
Yes, but I mean, were you obliged to pay them this amount?
In terms of the work that was executed, yes.
The work had already been done.
Yes.
Then they came to you and they proposed that you pay them 166 million.
No, it was on the basis that the work was being done at risk.
Yes. I see. And when it was agreed that, who agreed that the work would be done at risk? You?
Well, in terms of the understanding out of this LOI, Mr. Chair, it was de-scoped at this time. At this point in time, it was de-scoped, but it was not on the basis that the work would never be done.
It was rescoped, it didn't provide for it.
Sorry, sir?
It was rescoped in the sense that it didn't provide for it, it gave a fixed fee.
No, I don't think the fixed fee included the issue of the actual fundraising in terms of the mandate that was then concluded.
Yes, well, that's really what I'm getting at. Was this fundraising? Because
No.
just now you said it wasn't fundraising, you said it was advisory services.
In terms of the advisory services that was performed by regiments relating to the cross-currency swap and the JP Morgan, the cross-currency swaps with JP Morgan and the China Development Bank loan.
Mr. Singh, did it involve fundraising or not?
No, Mr. Chair, this related to advisory.
Advisory services. And you say it fell outside of the 20 January document.
Yes, sir.
All right, do you have any other comments you want to make on the memorandum at 1039?
Other than the fact that the memorandum covers the value that was added through the process, I think you also raised a question yesterday relating to the...
I'm sorry, Mr. Mabek, are you going back to Band 5?
Yes, the memorandum 1039.
1029 or 1039?
1039.
39, yeah. Okay.
I think there was one additional question that you had relating to a query by a certain Mr. Bloom, I think it was.
Yes.
I did have opportunity to reflect on that. I have not seen Mr. Bloom's comments. I just take it on face value in terms of the manner in which you've proposed it to me. You would have regard for the fact that I did say there were two streams of work that was performed. One was advisory relating to the cross-currency swaps, and one was advisory relating to the reduction of the cost relating to the China Development Bank funding facility. So from that perspective, there is two different streams of work that was performed by regiments, and that may account for the difference in the expected fee that Dr. Bloom was referring to versus what we had actually paid.
All right. Now, can I take you to the related evidence of Ms. Mahato? And that you find in Exhibit BB10. Now, perhaps I could, sorry, if you could turn, I'm going to pick up from page 29. Mr. Singh, perhaps I could just summarize aspects of Ms. Mahato's evidence. You've dealt with it in an affidavit, and then we can go through it in more detail. But, I mean, essentially, the point that she makes is that, in her view, there really wasn't a need for regiments. She gave evidence about a trip to Beijing with you in July 2014 to meet China Development Bank. She testified about the fact that when she returned from Europe after further international travel at the end of July, she was shocked to find out that Regiments was on the scene and negotiating with CDB. And then she talks about various emails and memos that she sent to you and Mr. Malefe about her concerns regarding regiments. And it's that exchange where you put in a memo, she put in a memo, it was noted by Mr. Malefe, and then she ends off by referring to the conclusion of the CDB agreement. You've studied her evidence, I take it.
The relevant paragraphs that was referred to in the 10.6.
All right. Well, let's go to at page 29. She talks about, at paragraph 113, a trip, and that takes us to 115. She says, on 1 July 2014, Anoj Singh and I attended the planned meeting with CDB in Beijing. The discussion started with normal greetings and introductions. As we were busy with introductions, a young Chinese official handed out a page dated 29 October 2013 to everyone in attendance with a list of names on it. You confirm that you had this meeting on the 1st of July 2014?
Mr. Chair, I don't offhand recall the 1st of meeting, July 2014 meeting, but I don't have any need to doubt Ms. Mahato's version.
Yes, but you do presumably recall going to Beijing in July, together with Ms. Mahato.
Well, the reason why I don't recall it specifically, Mr. Chair, is that I've had quite a few occasions to visit Beijing, not only for CDB, but other investor meetings as well.
But do you not remember the meeting you had?
I remember having meetings with CDB, but this particular one, I cannot confirm that I did or didn't have it.
So had you had other meetings before this with CDB?
I may have, so I don't recall.
And if you go to 116, she says, I may be speculating.
I'm sorry. I think Mr. Singh, Mr. Maibek was also asking whether you don't remember a meeting where you went there with her, with Ms. Mahato.
No, Mr. Chair, there would have been occasion for me to have a meeting with CDB with Ms. Mahato.
Or there would have
There would
been
have
more
been
than
occasion.
one or just one, as you recall.
I do not recall. I would
But at
assume
least
that
there
there was
would have been one.
that there would have been at least one.
Okay, all
Yeah.
right. Okay.
All right. She says at 116, I may be speculating, but given the demeanor of everyone who received the 29 October 2013 list, I suspected that a meeting might have been held on that day and that discussions and possible agreements might have been reached. What do you say to that?
Mr. Chair, as she says, she may be speculating. Mr. Chair, I don't recall this 29 October 2013 list or the nature of the meeting that would probably potentially occur on the day.
Had you gone to Beijing and had you attended a meeting with CDB before the 1st of July 2014?
Mr. Chair, as I say, I will be really speculating. As I said, I've been to Beijing on a number of occasions for CDB meetings particularly, and other meetings relating to investors as well. So it could possibly be true, but I cannot completely confirm that if I was there on the 29th of October.
Then at paragraph 121, she says, we continued with the discussions, though we had to start from a zero base. The discussions lasted the whole day. We finished between 4:30 and 5. As we were making our way out, Anoj Singh requested to have a private discussion with the executive in charge of the CDB Henan branch, together with an interpreter who was fluent in English. The meeting lasted approximately 30 minutes. You want to comment on that?
Mr. Chair, there's nothing unusual around the CFO having a discussion with the counterpart of the bank, and the discussions, I would assume, would have been around the fact that we're discussing the, let's call it, more strategic relationship between China and South Africa and Transnet, and the impact of the how can I say, the impact that the loan would have in terms of the South African environment and the country. So it would have been discussions around the more strategic nature of the relationship between CDB and Transnet.
All right. Then at paragraph 122, after the meeting, Anoj Singh told me that his travel plans had suddenly changed and he was no longer traveling back home with me the following day. He indicated that he'll be traveling via London to South Africa that same afternoon. He then requested me to collect his suitcase, which he had left in his hotel room before I leave for South Africa. The following day, before I booked out of the hotel, I picked up Anoj Singh's red suitcase from his room. I travelled back home with my luggage and his red suitcase. I don't know what was in the suitcase. I don't know what his suitcase contained as I didn't open it. You want to comment on that?
Mr. Chair, I deny this ever took place. I don't recall ever giving any of my luggage to anybody, and it's a highly strange thing for her to say, but as I said, I deny, I don't recall.
He says at 1:23, when I landed at OR Tambo Airport, I thought I'll take the suitcase with me when I go back to work. However, when I switched my cell phone on, I received a message from Anoj Singh that his driver will collect his suitcase from me at the airport. When I entered the arrival hall, I met Anoj Singh's driver, who collected the red suitcase from me?
Well, Mr. Chair, I don't have any recollection.
You have now, or did you have then a red suitcase?
Not that I recall.
Well, when I read this, or when I had her give evidence, the thought that crossed my mind is why you would have asked her to take this suitcase with her instead of traveling with your own suitcase. It seemed strange to me.
Well, that hence me saying it seems strange to me too, Mr. Chair. As if I was going to London, what did I go to London with?
Chairperson, sorry, we can't hear you.
Even me?
We couldn't hear you, the question that you posed.
Oh, okay.
If you can
okay.
please just repeat it so that we can hear it.
Well, I just said to him when this witness gave evidence and when I read the affidavit, it seemed a strange thing that he would have asked somebody to take his suitcase and come back to South Africa with the suitcase, and he went via another route. So his response was it's strange to him as well, because why? What would he have taken with him to London? That's what you said.
That is correct.
Yeah. Of course, the other question is, it would also be strange, would it not, for her to fabricate such a story, isn't it? It's say somebody asked me to take their suitcase with me while they travel somewhere, and when I arrived at OR airport, I thought I would take it home and then come to work with it on Monday or whatever, next working day. But then there was a message, he said somebody will pick it up, and somebody picked it up, and that's where it ends, because that's where it ends. Nothing turns on the whole thing. But it's not the kind of thing one would expect somebody to fabricate.
Well, equally, Mr. Chair, it wouldn't be something that I would request from someone to do. And Mr. Chair, I mean, I'm not too sure why she would do this, Mr. Chair, but again, if you look at the procedures of the airport, Mr. Chair, one of the things that they would ask you is, are this all your bags? Are you traveling with your own bags? Did anyone pack your bags for you? So she would have had to make these declarations. How did she make those declarations at the airport?
But would she be somebody that you would have thought she would fabricate something against you in terms of your relationship?
Well, as I've characterized my relationship with her, it was cordial and professional. So,
yeah. Okay. Mr. Maivek.
Thank you. And then to pick up at page 31, I'll fast forward to paragraph 126, under the heading Regiments Taking Over the CBD Negotiations. Upon my return from Europe, which was around in July 2014, I was shocked to find out that CBD was now communicating directly with regiments and that Eric Wood was leading the negotiations. This was in parallel to Transnet furthering negotiations with CDP. Do you want to comment on that?
yes, Mr. Chair. I think at this point in time, I think we need to understand the context. And I think, again, not to, well, the context at this point in time was that given the fact that we had signed the locomotive agreements in, I think it was March 2014, the locomotive agreements that we had signed created a commitment for us to be in a position to pay against the locomotive agreement. Now, one of the criteria that the rating agencies employed at Transnet, I think it was particularly S&P, was a ratio called an AB ratio. And the AB ratio basically looked at the committed funding facilities that any entity would have versus the commitments that that organization had in terms of being able to pay. So they would basically look at and say, okay, your cash from operations is X, your committed facilities from banks is Y, your committed funding facilities is Z, add all of that up if it came to 10. And if you then had capital commitments or contractual commitments to pay, they would then add that up, and if that came to, let's say, 5, then your AB ratio was 2:1. And that is the ratio that they would, that is one of the ratios that they actually was quite particular about in the case of Transnet, because we were in a significant capital expenditure program at the time. And so we were under significant pressure to be able to demonstrate to S&P that we had a AB ratio that was acceptable to S&P. In terms of the treasury function at the time, Mr. Chair, Ms. Mahato and the team had been reaching a point where there was not significant traction on the discussions that were happening with China Development Bank. And then this is where, at the point at which I then decided to get Mr. Wood involved and regiments involved to understand to what extent they can actually accelerate the process and the discussions with China Development Bank with a view to conclude a transaction with China Development.
So at 127, she says, I again complained bitterly to both Anoj Singh and Brian Malefe, as I believe there was no need to use regiments because of our internal treasury capacity. And then at 128 and further, she says, Anoj Singh and I continued to argue about the CBD pricing proposal. And that then, if you look at 131, gave rise to a meeting with Mr. Malefe. Would you agree with that?
Again, I don't recall this meeting, Mr. Chair, but I have no reason to disbelieve Ms. Mahato's version of the meeting.
So at 131, Brian Malefe, I beg your pardon, organized a meeting between Transnet and regiments to resolve the CDB pricing proposal impasse. The meeting was held at the Melrose Arch Hotel. Transnet was represented by Mr. Singh Malefe and myself, regiments by Eric Wood and Niven Pillay. Is that right?
That's
And then she records that Mr. Malefe suggested that everyone seemed to think that my pricing indication is off the mark and that the one that Eric Wood received from Nedbank seemed reasonable. I should agree with them, as I was the only one who didn't agree. I told Brian Malefe that my position had not changed and will not change, as the CDB facility is expensive and not worth it. Do you confirm that that was the stance that Ms. Mahato adopted at this meeting?
Mr. Chair, as I said, I do not recall this meeting. But again, if Ms. Mahato says the meeting happened, I would take it on face value.
Then at 1:33, I then decided to record my recommendation and concerns. On 21 August 2014, I sent an email to both Brian Malefe and Anoj Singh detailing my key concerns. Can we just go to that email, please? That you find at page 241, MEM 241. So at 241, in the email that she addresses to you and Mr. Malefe, in the first paragraph, she says, this email is a follow-up of various discussions I had with yourselves, and in some instances with regiments included, where I'd indicated my discomfort and disagreement on how the China Development Bank facility negotiations are being handled, regiment's pricing methodology, as well as my disagreement of the appointment of regiments as the transaction advisor for the facility. For the avoidance of any doubt, I'd like to bring the following to your attention. And her first point is, in respect of your executive authority and powers that go with it. I respect your executive authority and powers that go with it. But I also believe that it is my responsibility as the current Transnet Group Treasurer to advise you on matters relating to Treasury activities. As I indicated, I was not consulted, nor was I aware that Regiments was appointed as the transaction advisor and lead negotiator for the facility, as I believe there is no need for them to be appointed given the progress that we have made. You want to comment on that?
Mr. Chair, I think again here, the reason that regiments, or Ms. Mahato refers to regiments being the lead negotiator. When we had the discussion with China Development Bank in terms of having regiments part of the team to be able to negotiate and conclude the transaction, there was a request from them that said, listen, we understand that we're dealing with Transnet. To the extent that Transnet requires us to deal with any other party, there would need to be a letter from us that actually recognizes the identity of the other party. And from a bank's perspective, the only other people that they would engage with, other than the, let's say, principal, which in this case would be Transnet or Transnet team, would be people that they recognize as lead negotiators or lead arrangers. So that's the reason we sent a letter to CDB, or I sent a letter to CDB, informing them that regiments would be part of the team as lead negotiators together with Transnet.
But do I understand your evidence crisply really to be that as far as you were concerned, Treasury didn't have the capacity to handle this sort of transaction?
Well, ostensibly they failed to have reached conclusion with CDB for
Sorry,
the
I
time.
can't hear you, Mr. Singh.
I said they had failed to reach conclusion with CDB up to that point in time.
Yes, but do
But
I understand
is that
your...
because of lack of capacity? I think that's the question.
Well, Mr. Chair, it was basically Ms. Mahato, then there was Ms. Dorothy Kobe, and I think there were two others at that point in time that made up the full debt capital markets team at the time. And Ms. Kobe was relatively new, I think, at the time. Ms. Mahato was relatively new in her position of group treasurer. I think she was just appointed, I think, 9 months before that, if I recall. I don't recall correctly. And she had not run a corporate treasury before. So that was the context within which the funding or the funding plan of Transnet was being executed at the time, together with the fact that we had to demonstrate to S&P the fact that we had an adequate A and B ratio, as I explained.
So the short answer is that you're saying there was no capacity at Transnet's treasury.
In my view at
That's
the
what
time,
it amounts to.
in my view at the time, Mr. Chair, Transnet Treasury had the ability to take care of the normal, mundane, and day-to-day activities that related to funding. In terms of this particular funding facility for the locomotives, it was a significant amount. We needed to raise 50 billion rand for the locomotive. It was not a small amount. The local debt capital market probably would have been able to do it over a period of time. But in order for us to be able to deal with the A and B ratio that S&P had asked us to comply with, there needed to be urgency relating to the fact that we needed to conclude contracts. The contract with US Exim and I think there was one additional one, I can't remember right now. I think it was Canadian Exim, or I think it's in my affidavit, Mr. Chair. But there were two additional contracts that we had been negotiating, which also were behind schedule in terms of being able to be concluded. And the fact that those two agreements were not concluded in time, there were certain penalties that we incurred. When we say penalties, it was not physical penalties that we had to then pay 10 million rand, for example, but in terms of higher cost of debt, in terms of being able to miss the appropriate timing of the market. So, Mr. Chair, in terms of this, yes, the Transnet Treasury had capacity, the Transnet Treasury was there, the Transnet Treasury could do all of this, but at the end of the day, it needed to be done within a time frame, within the context of the requirements of credit rating agencies, given the fact that we had an exposure of 50 billion that needed to be met.
So Transnet Treasury did have the capacity, but it was thought that they would not be able to do it within the time that it was required to be done.
Mr. Chair, I think the context is the Transnet Treasury had the capacity to take care of the day-to-day funding that was required.
Yeah.
This was over and above the day-to-day funding, albeit that it formed part of the funding plan.
So they didn't have capacity to deal with this type of matter.
Mr. Chair, they did, Mr. Chair, they did conclude transactions with other development financial institutions. AFD, KFW, all of these people are development financial institutions. We had not concluded a transaction with China Development Bank before. Now, in terms of dealing with funders, if you dealt with them before, Mr. Chair, it's quite easy to conclude a transaction with them because you know what their pain points are. They've already dealt with you. They have already understood you. I think this was the first time that actually China Development Bank was making an investment into South Africa. So there was a significant amount of, how can I say, groundwork that needed to be done to be able to make them understand the South African market, firstly, and what they were getting into, and secondly, what our expectations were and what our alternatives were. Let's put it that way. Because I think one of the things that we found with China Development Bank was that they believed that we had no other alternative other than to come to them for funding. And this was one of the issues that we needed to get across to them, was that, yes, we need your funding, but understand that we actually do have alternatives.
Mr. Maybeck?
Yes, thank you. Perhaps just dealing with or evidence about the size of the team. Could I ask you, please, to go to page 4, MEM 4, and have a look at paragraph 7.
MEM 4.
That's in the same affidavit, is that page 4?
Yes.
Paragraph 7. The Treasury team, are you there?
Yes, sir.
Had a complement of about 40 staff members, i.e. 32 professionals supported by 8 administrative staff. Professional staff in Treasury had multidisciplinary skills, competencies and experience. This included mathematicians, accountants, investment bankers, commercial lawyers, traders, financiers and economists who were all highly experienced with an average 10 to 30 years of experience in their respective fields. You want to comment on that?
Yes, Mr. Chair. But Ms. Mahato fails to actually say how many people of those 32 professionals were actually involved in the middle office in terms of fundraising activity. As far as I can recall, Mr. Chair, I don't think there were more than 4 or 6 people in the debt capital market structure at that time. But I do stand correction because it's a long time, but I do recall that it was not many people.
Then have a look at paragraph 13 at page 5. In the months following my appointment as head of structured finance, I capacitated my area by appointing 2 professionals and later added 2 additional resources. Paragraph 14, in addition, more professionals were appointed to the Treasury team, including professionals in Treasury operations to handle complex financial accounting matters, a forex trader, and additional cash and debit debt management professional.
So paragraph 14 actually has nothing to do with fundraising or capital raising. Paragraph 13 is more appropriate. As you can see, when she was appointed head of structured finance, she basically appointed, let's say, 4 people.
Yes. Perhaps we could just go back to 241. In the middle of the paragraph, under the heading Overall Governance, it says, when we negotiate and enter into agreement with lenders and investigators, we make certain undertakings and covenants that should apply to future facilities as well. The fact that Transnet's biggest ever transaction is negotiated and decided by outsiders, in brackets regiments, is a cause for concern as it exposes the company to undue risk. When we negotiate a facility of this magnitude, we assemble a multidisciplinary team that includes legal, tax, accounting, structured finance, and risk management team members. This is to ensure that all potential risks relating to the facility are identified and mitigated to the extent possible. You want to comment on that?
Well, Mr. Chair, firstly, when Ms. Mahato refers to the fact that Transnet's biggest ever transaction is negotiated and decided by outsiders, I would assume she's talking about local transaction, or is she talking about this funding facility?
Well, you'd be better placed than me, Mr. Singh. You responded to this memo.
Mr. Chair, if she's, well, in both cases, Mr. Chair, whether she's referring to the CDB funding facility or whether she's referring to the locomotive transactions where they also played a role as transaction advisors, Mr. Chair, they did not negotiate. At the end of the day, ultimately, the advice comes from transaction advisors. What we as Transnet management decide to do with it is up to us. They will always advise. We will basically agree with some advice. We will disagree with some. But whatever we believe that is in the best interest of Transnet, we will then engage with either the OEM or whether it was CDB. In this case, Mr. Chair, when she says that the facility of this magnitude, we assemble a multidisciplinary team of legal, tax, accounting, structured finance, and risk management. Mr. Chair, there was no difference when we concluded the China Development Bank transaction. All of these different legal, tax, accounting, structured finance, and risk management teams were all included. You will see later on, Mr. Chair, when we actually, maybe if we get there, you will see there were certain proposals that were made that were recommended by regiments together with JP Morgan that were rejected. And they were rejected particularly for the adverse accounting consequences that it may have for Transnet. You would recall yesterday when we read an email from Mr. Danny Smith in terms of the transaction advisory stream that they were advising on. And you will recall, Mr. Chair, that Mr. Smith said that Mr. Pillay had provided significant insight into options. Now, these are options that we would consider in terms of dealing with the foreign exchange risk relating to the locomotive contracts. But those option opportunities, let's call it the option opportunity that was proposed by Mr. Pillay, was not considered. And was not considered because, again, of the adverse tax and accounting implications that it would have on Transnet. So notwithstanding the fact that regiments was involved, it did not take away any of the other processes, or it did not override any of the other, how can I say, internal, normal internal processes that would happen. What regiments would bring to the table? They would bring options. When I say options, now, these are not the financial instrument options, but they would bring different thinking or different alternatives, let's say alternatives to the table. It was then up to us to decide whether those alternatives were appropriate or not, were good or bad or indifferent. And that is what then would go to each one of these legal people, tax people, accounting people, structured finance people, risk management people, to engage, to understand whether this thing that is being proposed, is it good, bad, or indifferent?
So we then go back to page 33 of the memorandum, sorry, of the affidavit. We see at page
So page 33.
Page 33, MEM 33. We see at paragraph 135 that you then wrote a responding memorandum, correct?
Page 130.
135, paragraph 135 at page 33.
So this is,
Anoj Singh wrote a memorandum in response.
yeah, but I'm trying to understand whether this memorandum is in response to the email or is it in response to another memorandum?
It's in response, it seems, to the email.
No, I don't think so, sir.
All right. Well, let's go to your memorandum that you find at, well, let's perhaps, if, insofar as it's important, at 133, Ms. Mahato says that she sent an email to you, and
So this is the one I assume we just
Yes.
looked at, correct?
that's the one we've looked at.
Yes.
All right. And then she goes on to say, however, regiments recommended that Transnet should proceed with the transaction, etc. And then at 135, she says, Mr. Singh wrote a memorandum attached as Annexure MM33 in response to the concerns that I had raised.
Okay, that's
Okay.
correct.
So I want to take you to 285. That's where you'll find your memorandum.
So it's MM36, right?
Yes.
Page?
285. You signed this on at 287. Is that 21 August?
It's probably 27.
27 August 2014?
Looks like.
Is that right?
That is correct.
All right. So at 285, you see China Development Bank locomotive funding response. And ultimately, at 287, you seek this recommendation. 5, it's recommended that the Group Chief Executive approve the response to the Group Treasurer for issues raised on the USD 2.5 billion loan facility with China Development Bank. So what you were asking really was that Mr. Molefe should prefer your response over Ms. Mahato's email.
No, I don't think that was the purpose of the memo. The purpose of the memo was to, as you would have seen in terms of the email correspondence and the communication, Ms. Mahato had a tendency of actually not coming through my office, but going directly to Mr. Molefe because of a relationship she had with Mr. Molefe from National Treasury. So the purpose of this email was to actually not have this he said, she said, but to get to a point where if Mr. Molefe believed that she was correct, he needed to say it.
Yeah.
If he believed I was correct, he needed to say it.
I think we're saying the same thing.
Yes.
Yeah. All right. It was to resolve the impasse one way or the other.
Yeah.
So you didn't feel comfortable taking the decision yourself. I mean, you accepted it was contentious.
No, it was not contentious. This was a mechanism to deal with the let's call it, for want of a better word, the HR issue.
And Mr. Molefe then didn't do what you wanted.
Yes, evidently.
Correct.
I think he noted, yes.
Yeah. To take you to page 285.
That's 2.
285.
Oh, just the previous page. Okay.
You talk about regiments, paragraph 3A. Regiments Capital was appointed as transaction advisors. In terms of the aforementioned mandate, Regiments Capital was required to advise on deal structuring, financing, and funding options to minimize risk for Transnet. Correct? We've seen that.
Yes.
Accordingly, the negotiation with CDB to successfully conclude a ZAR funding facility at a ZAR cost not exceeding 9.3% for a tenor not less than 15 years at no additional fee is part of their mandate. Is that correct?
Yes.
So this was part of their original mandate?
Yes, based on this memo.
Yes. And you say this as at August 2014?
Yes.
Then if I could take you back, please, to page 34. So now, by this time, Ms. Mahato at 136 has mentioned that Mr. Molefe noted on your memo.
We now at one? Yes.
She says at 137, at page 34, on August 2014, I drafted an internal memorandum to the board seeking approval for funding initiatives subject to acceptable terms and conditions. And then she goes on to say at 138, I later discovered that Anoj Singh had replaced the Treasury Board memo with a PowerPoint presentation that was based on the flawed regiments analysis. So it seems that this junction between the two of you continued.
Yes, sir.
And then, just to complete the chronology, at paragraph 140, at page 35, it says, pursuant to Anoj Singh's representation to the board, the attached CBD term facility agreement was signed on 4 June 2015, committing Transnet to, as she says, a very expensive loan agreement. But leaving that aside, you accept that the agreement was concluded on the 4th of June 2015.
I don't recall the date, but I can confirm that we did conclude a term facility agreement with China Development Bank.
Perhaps I could take you, in conclusion of this, to Mr. Mohammedi's evidence. So if I could just have a second, Chair, please. I think I've seemingly mislaid one of my files. But I'm going to have to come back to that perhaps after the key adjournment. Perhaps what I can do is I'm going to take you to his affidavit when I find mine. But let me just quote to you what he said in evidence from the transcript. He, in his evidence, concluding that the terms of the CED loan made no commercial sense to him. he testified that, and this is a quote, the only possible plausible explanation from my perspective would be that there was an agenda for payment to be made to regiments, ultimately, or some entity that existed outside of the system. He said that on day 93 at page 144 of the transcript. Do you want me to read that again? It says the only possible plausible explanation from my perspective would be that there was an agenda for payment to be made to regiments, ultimately, or some entity that existed outside of the system. Want to comment on that?
Yes, Mr. Chair. Firstly, Mr. Chair, I don't think Mr. Mohammadi is competent to make that assessment. I don't think he's actually been involved in a loan negotiation in his professional career that would require a facility of $2.5 billion from Chinese investors. And I say that very particularly because investors are finicky about what they want. So when you deal with US investors, there's a particular format in which they want loan agreements to be. There are certain formats in which there are certain terms and conditions that they will accept. There are certain terms and conditions that they won't accept. When we dealt with the Chinese, there were certain terms and conditions that they would accept. There were certain terms and conditions that they would not accept. And Mr. Chair, in terms of the CDB loan facility that was concluded, Mr. Chair, if I do have an opportunity at the tea break, I will reference my affidavit. There is attached thereto a document that effectively outlines the benefits associated with the China Development Bank loan facility that I think will go a long way to put Mr. Mohammadi's concerns at ease.
See, the other thing that Mr. Mohammadi said, and I think that's in the affidavit, which I for some reason can't locate, is he echoed Ms. Mahato's position, and that he felt that Treasury would have been able to do this job.
Well, Mr. Chair, again, with hindsight, it's perfect science to be able to say, yes, I think they would have been able to do it. Mr. Mohammadi was part of the group finance team at the time. He was part of the locomotive acquisition process. And had he had the foresight to say that, the Treasury team could have done it at the time, he should have raised his concerns at the time with me. But he did not.
I want to finish off Ms. Mahato's affidavit by taking you to something different. Could you please turn to page 19?
19. So it's
19?
MM 19.
Yeah, MEM 19. This is something that I dealt with Mr. Malefe. I'd like to just deal with it now from 71 to 76, not very long. She talks about the fact at 71, about 5 lines down, on that day, and that would have been in about the third quarter of 2015, Anoj Singh gave me a funding proposal from regiments in hard copy and informed me that it was a very important matter that Brian Malefe needed executed speedily. He said that I should excuse myself from attending FinCo and CAPIC and rather spend the day working on this urgent proposal and draft a memo recommending the proposal for his signature and approval by Brian Malefe. Would you comment on that?
Mr. Chair, I don't recall the specific event in terms of being able to provide this proposal to Ms. Mahato. I did receive proposals from regiments, from APSA, from all the banks regularly. And the first thing that I would do, Mr. Chair, is take the proposals and provide it to Treasury and say, we've received this thing, please review it and let us know what you think of it. So it was a matter of course.
Well, what this reflects is that what was required of her was to draft a memo recommending the proposal. for Mr. Malefe's signature and approval?
Mr. Chair, it's unlike me to basically say to anyone to take something and draft a memo on the basis that it's not reviewed or understand the implications thereof on Transnet.
Well, that I think is the issue. Because she says you did do that.
I deny it.
You deny it.
Yes.
At 72, she says the regiment's proposal was that regiments will facilitate a 5-year, 5 billion rand loan facility that was to be funded by Nedbank. You recall that?
Mr. Chair, as I said, I don't recall specifically this regiment's proposal, but as I said, the reason maybe is because I received proposals almost weekly from banks, if not more frequently than that.
Yes, but just to retrace the steps, it's not a matter of simply receiving a proposal. On her version, she says that you wanted her to cancel all of her meetings and spend the day working on an urgent proposal and draft memo recommending the proposal.
As I said, this would not be something that I would have proposed to Ms. Mahato.
Then at 73, she says that the proposed facility was priced much higher than normal facilities or smaller loan facilities or domestic bonds. My calculation indicated that Transnet would have to pay an additional 150 million per annum in interest payments over and above what Transnet normally pays for similar facilities. This translated into potential losses of 750 million over a 5-year period. I shared my analysis with Anoj Singh and indicated that I did not recommend the proposal given potential excessive costs in interest payments. He responded saying that it is an instruction from Brian Malefe and that I should quickly complete the memorandum for approval the same day. Want to comment on that?
Mr. Chair, as I said, I don't recall this, and this is not something that I would have instructed Ms. Mahato to do in any way, shape, or form.
At 74, I felt very uncomfortable with the same-day approval request, as we had never rushed funding initiatives before and definitely not same day, especially given the potential losses of 750 million over a 5-year period. She goes on to say at 75, I decided to discuss the matter directly with Brian Malefe and went to his office. I told him that I understand that he expects me to urgently recommend a 5 billion rand 5-year loan that Regiments is proposing, wherein 150 million would be unnecessarily incurred per annum, accumulating to 750 million over a 5-year period with no clear benefits for Transnet. I was irate at that time that I explicitly told him that should we approve the structure, we will go to jail for stealing money as we are the custodians of Transnet's funds. And then this piece concludes, the structure was overpriced, we had a direct relationship with Nedbank, there was no need to use a conduit like Regiments to engage with Nedbank. Brian Malefe agreed with me and said that he will handle the matter. The structure was never implemented. Do you have any comment on that?
Mr. Chair, I don't recall Mr. Molefe ever engaging me on this matter, to the best of my knowledge. This was never discussed between Brian and myself. Mr. Chair, if this was actually something that was faced in reality, my response to this issue would have been to Ms. Mahato to engage with Nedbank to understand why was Nedbank, as she says, we had a direct relationship with Nedbank. Why would it be necessary for Nedbank to engage with us via Regiment? So that would be something that I would have raised with her at the time. Given that this was which seems like a relatively vanilla funding facility. There was nothing extraordinary about this, except that they were providing money to us. So there was no need for regiments to be involved in this in any way, shape, or form.
I'd like to turn now to a different topic. Chairperson, I don't know if this would be a convenient time to take tea.
Yeah, maybe it would be. Let's take the tea adjournment. It will be 15 minutes. We adjourn. Okay, let's continue.
Thank you, Chairperson. Mr. Singh, you said that you wanted to reference a document. Did you manage to find it?
That is correct, sir. I did. It is actually in bundle BB23.
Right? Is that bundle 5B or 5A?
5C.
Sorry. Yours. Okay.
5C.
And you said that page?
Page, black numbers, 1551.
155. Yes.
And we'll just wait for Mr. Chair to get his document.
That's Annexure AS4, is it?
That is Annexure AS4, that's correct.
Please go ahead.
Thank you, sir. Mr. Chair, you will recall that Mr. Myberg led some evidence relating to Mr. Mohammadi's comments. And
Yes.
I responded by saying that there is a document that outlines the benefits relating to the China Development Bank loan. And this document, Mr. Chair, purports to record that in terms of the value that was added through the regiment's interactions with China Development Bank. Mr. Chair, if you look at 1557, you will see that this is a summary of the value added from negotiation support provided by regiments. A 15-year amortizing profile was negotiated as opposed to CDB's proposed 10-year amortizing profile. The longer profile duration provides a better asset management liability match. So, Mr. Chair, basically what this means is that China Development Bank had offered a 10-year facility, meaning that you would repay the loan in 10 years. But we insisted through regiment's interactions with China Development Bank that it actually suits Transnet better if we have a 15-year facility, in that the locomotives actually are long-term assets, because it takes 3 years for them to basically be built and come into production. So if you give us a 10-year loan, we basically only have 7 years to repay this loan. It then becomes quite expensive. So the longer the duration of the loan, the better revenue generation and repayment of the loan. So you have better matching of the revenue generation of the asset, so you generate the revenue from the asset and then have the ability to pay the loan. The capital grace period was extended from 36 to 54 months. And again, Mr. Chair, in terms of the capital grace period, this is basically a grace period between which you actually draw down the facility. So let's say you take the money today, but the grace period then enables you a period of 54 months within which to then make your first payment. So you're actually allowing the entire period during which the locomotives are being built to actually not pay anything on the loan. The CDB initial pricing was 300 basis.
Of course, I take it, although you are not paying, the interest is being added on.
Well, you'll have to accrue the interest, Mr. Chair, because you've got the benefit for the facility. You've actually taken the money, except that you're not repaying capital because the locos are not yet generating any revenue. CDB's pricing, Mr. Chair, now pricing is the actual cost of the facility. You will see it was originally 300 basis points, and it ended up being 257 basis points. Which is a 43 basis point saving. Then, Mr. Chair, as you can see, the fourth bullet point, in order for us to have an appropriate level of interest cost relating to the locomotives, because the locomotives was a significant chunk of the capital. If you recall, we said that we had a capital spend of 300 billion. The locos was 50 billion of that. Now, that's a significant portion of the entire, it's almost 20% of the entire capital spend that we're going to do. So if you locked yourself into a very expensive facility for 20% of the facility of the capital, it will be a burden on the interest line for quite a significant amount of time. So in order to actually get to a point where we had an acceptable level of interest cost, we actually decided to do a blended facility, which is a dollar facility as well as a rand facility. Mr. Chair, you have to accept, it is just economics, that when you borrow in South African rand, it is cheaper. When you borrow in US dollar, it is more expensive. And it is just because of the currency. And obviously other factors, but the biggest point is that, simply put, it's just currency. So each time you borrow overseas, it's actually more expensive than borrowing local. So in order to manage that appropriately, you had to have a blend of rand financing as well as dollar or any other currency financing. Then, Mr. Chair, if you go into the next page, you'll see that we actually had other interactions that we've also achieved. That's on page 1558. So these are relatively technical details, Mr. Chair, but basically, in terms of the change of the reference rate, so Mr. Chair, the reference rate means that the cost of the debt or the interest cost, you could either do that quarterly or biannually or annually. And depending on which one you choose, ultimately, the amount of debt that the amount of interest that you actually pay over the life of the loan is different. So in changing the reference rate from, let's say, annually to semi-annually, quarterly, there's either a saving or there's a cost involved in. So that was identified and captured. Sensitivity in executing the CCS. Now the CCS stands for a cross-currency swap, or a contingent cross-currency swap in this case. This was executed with JP Morgan, and it resulted in a saving of a further 112 basis points. But in executing strategy, Mr. Chair, in terms of the contingent cross-currency swap with JP Morgan, was changed. And that was the reason why we actually had gone to the ADC, if you recall on that memo, to request the ADC to confine the CCDS to JP Morgan. Because what we actually found, that is, if we go to the market and say to the market, now the market is, if you're executing a swap, you have to execute it with a counterparty. Now the counterparty can only be the banks. Now, as soon as you approach the banks to say them, give me a quote, they already know that a transaction is coming. Well, why else will you ask them for a quote? Right? And the way that you ask them, the way you test the market is you ask a number of banks. But as soon as you ask a number of banks, what happens? All of them know a transaction is coming. And automatically the price for that instrument immediately goes up by 10 to 15 basis points. So in order to prevent that, what we call front running of the transaction, because of the size of this transaction, those 10 or 15 basis points actually add up to quite a lot of money. So what was decided in this transaction was to say, let us test JP Morgan's pricing. If we are comfortable with JP Morgan's pricing, there's no need for us to go and test the market in executing. So we'd actually just execute with JP Morgan alone and not run the risk of adding 10 to 15 basis points on the transaction relating to the front-running risk. The other, I will move to the other two items on page 1558 I will skip, as well as the two items on page 1559 I will skip in the interest of time, Mr. Chair. But it's the affidavits on record, the Annex J is on record, Mr. Chair.
Yes.
The last one that I would like to actually comment on is the last thing on page 15, or the last item on page 1559, which relates to the standby facility. Now, Mr. Chair, of all of these things that I've mentioned to you, me as CFO, actually this standby facility was actually the most important thing that came out of this entire thing. Because as I said to you originally, the reason why we actually or why we actually opted for regiments to partner with Transnet Treasury to negotiate the facility with China Development Bank was actually for us to satisfy what we called the requirements of S&P in relation to the A and B ratio. Now, having signed a facility with China Development Bank of $2.5 billion, if you go into the detail of the loan agreement, Mr. Chair, the facility was for $2.5 billion, but the commitment to draw down was only $1.5 billion, which meant there was $1 billion that China Development Bank had committed to us with no actual drawdown requirement. So that was as a facility that we could determine whether we required it in, I think, in 12 months or 18 months into the future. But the facility was there. So it was a commitment that China Development had given us in writing that we had $1 billion available to us at any given point in time. So that satisfied the requirement of S&P as a committed facility. So the $1 billion basically was there, enabling me to satisfy S&P's commitment in terms of the A and B ratio. So to me, Mr. Chair, this was one of the things that was really, really helpful in terms of being able to satisfy S&P requirements. So, Mr. Chair, this I submit as the benefits relating to the China Development Bank facility in response to Ms. Mahato's comments and criticism and Mr. Mohammadi's comments in relation thereto.
Thank you.
So you've, as I understand it, addressed the value that you say regiments added.
That is correct.
I think the essential controversy, though, is whether the internal treasury couldn't have added the same value.
Well, hence, Mr. Chair, I would then ask the question, where were all of these things that I just read out to you? There were none of these ideas that emanated from Transnet.
Yes. But of course you engaged. They didn't have the opportunity to do that, or do I get the chronology wrong? What happened is when Ms. Mahato came back from travels in the middle of July, you had engaged Transnet, regiments.
No, Mr. Chair, you would recall that they had an opportunity to engage with CDB for a period of time.
All right.
When those engagements, in my view, were breaking down, that is when regiments was
That's when you
on board.
approached regiments.
That's when I approached
All right.
regiments. But even then, to Mr. Chair, I think I would like to clarify and make this point very clear, and I thought I had done it before, but I'll reiterate. There was no point in time that I can recall where regiments had exclusive and unfettered access to either locomotive manufacturers or China Development Bank. Regiments worked in concert with Transnet Treasury for all intents and purposes. They worked with the cross-functional evaluation team when they were doing the locomotive negotiations, together with Transnet Treasury and the engineers. So from that perspective, it was not as if regiments had this and they then went off and there was no one else with them. It was never the case. If they were dealing with China Development Bank, there was always a case that they would deal with China Development. Maybe they didn't have a Transnet person sitting with them every time they spoke to China Development Bank. But certainly when the feedback was given to Transnet, it was given to Transnet on the basis that it was given to me as well as Treasury. There was no way that these legal people, the tax people, the other people that Ms. Mahato mentions in her affidavit would have been able to engage with these matters if regiments was going off and doing their own thing without interaction with Transnet, individuals and staff.
And sorry, there's something that I forgot to mention to you, just reminded me. Ms. Mahato alleges that you excluded her from the data room. It's something I didn't put to you. Do you want to comment on that?
Mr. Chair, again, I think Ms. Mahato does make that allegation. There was no occasion that I would have given an instruction like that for any reason. Ms. Mahato was, on her own version, a member of the cross-functional evaluation team. She had full access and rights to be in the data room and get access to any information she required. The data room was not under my control, Mr. Chair. As I mentioned in testimony yesterday, the entire evaluation process relating to the OEMs and the data room was actually at Transnet Freight Rail. It was not at corporate center. I had no oversight over that data room. It actually oversight relied with Mr. Gama and Mr. Jan.
And then perhaps I could just ask you with reference to your slide, page 1559, you mentioned to the chairperson that you thought the advice in relation to the standby facility was particularly useful and valuable. Do I understand you correctly? 1559.
There is, I'm there.
And is that that standby facility of $1 billion, correct me if I'm wrong, is that then what was dealt with by way of the ZAR club loan?
I would, this one and that one is not the same.
Are they different things?
They're different.
All right, thank you.
This is a standby facility. So if you needed it, you could have drawn down.
It wasn't another fundraising mechanism.
This one? No, this was, so if we, let's put it this way. If we needed this, there was no other agreement that you needed to sign. All you needed to send is a letter to CDB to say we are activating this facility and please provide us $1 billion.
And then I have now found, thankfully, my Mohammadi file, exhibit BB3A. BB3A. And could you please turn to page MSM 18, 18. So, Mr. Singh, I've already put this to you, but just for the purpose of the record, MSM page 18, paragraph 5.5.9, Mr. Mohammadi states the Transnet Treasury team had sufficient expertise to enter into loan transactions without the need for external support. In my view, there was no need for the above-mentioned loan arrangement fee to be incurred. And he then makes certain other statements to that effect. Do you have anything to add to what you've already said? I think you've already told the chairperson that, firstly, you don't think that he has the expertise to proffer this view, and secondly, if my memory serves me correctly, you said that if he had that concern, he should have raised it at the time.
That's correct.
And is it your evidence that he didn't do that?
That is correct.
And then perhaps I could just take you to one aspect, some regulatory issues. In exhibit BB27, so that's the POR bundle.
Can I just do some housekeeping once? I'm there, sir.
And I'd like to take you to page 395, part of the M&S Transaction Advisor Report. paragraph 2.7.12, in the middle of the page, the report reads, the guideline on cost containment measures, the DOA framework of 1 September 2014 and the PPM October 2013, all make reference to the use of internal skills and resources before the procurement of external consultants. It is only in the event that there are no skills and resources internally that a public institute, such as Transnet, may then procure external consultants. Now, do I understand you to be saying that Transnet did not have these skills internally?
Mr. Chair, I think, as I've said, in my view, Transnet Treasury was not sufficiently capacitated at the time to meet the needs of the organization at the time. That's why we engaged with regiments.
I appreciate that. And then, just for the sake of completeness, 2.7.13, further to the fact that Transnet is required to ensure that there are no internal skills and resources available to it before procuring external consultants, the Transnet DOA framework also places an obligation on Transnet employees / business units to, quote, always obtain on FX forward rates and liaise with Treasury trading desk that will verify the rates to ensure it is market related. The business units can only enter into the FX hedges with the supplier once the rates are accepted by the Treasury trading desk via email. Once the above approvals are obtained, the Treasury traders will sign off on the rate acceptance, close quote. Then at paragraph 2.7.14, the exclusion of Transnet Treasury in terms of the CDB facility was in contravention of the guidelines on cost containment measures and, which we've dealt with, and the DOA framework. The use of regiments should not have been approved without having obtained the Treasury traders sign off on the rate acceptance. You want to comment on that?
Mr. Chair, again, I think, as you would see in testimony that would follow, I think MNS takes elements of applicable legislation or procedures or policy out of context and uses it for their purpose to obtain a predetermined outcome, in my view. If you look at this particular DOA framework that they're actually referring to, Mr. Chair, and I'm not too sure if Mr. Chair would actually want to go to it. If you would like to, we can, because I think there is a delegation of authority framework attached in one of my affidavits. You will see, Mr. Chair, this delegation of authority framework that they refer to, and this issue of Transnet employees, Mr. Chair, and business units. This is saying that, remember, we have a centralized treasury, so there's a treasury department that does whatever they do and treasury activities. They are the only ones that are allowed to engage with banks, right? So what this is saying, it's saying employees other than these treasury employees, it makes reference to business units. Business units are all of the people outside treasury. So it will be Transnet Freight Rail, it will be Transnet National Port Authority, pipelines, and all of these other people. If they had to engage in a foreign transaction, if they had to engage with a supplier relating to a equipment that needs to be bought in dollars, what this says, they have no authority to commit Transnet to that particular rate that the supplier is offering without actually having reference to Transnet Treasury first. That's what the purpose of the delegation of authority framework, that is the purpose of why it is there. It's not this interpretation, Mr. Chair, that MNS applies to that provision of the delegation of authority framework is incorrect. And Mr. Chair, if you would like, we could go to that delegation of authority framework to look at that specific element.
So this comes from 2.7.12 and then goes up to 2.7.14.
So the one that I'm referring to, Mr. Chair, is 2.7.13.
Yeah.
If you look at the third line, it says,
Yeah, but let me go back to 12 first.
Yes.
The guideline on cost containment measures, the GOA framework of 1 September 2014 and the PPM October 2013 all make reference to the use of internal skills and resources before the procurement of external consultants, which all makes sense. It is only in the event that there are no skills and or resources internally that a public institute such as Transnet may then procure external consultants. I guess no problem there.
so Mr. Chair, there I've given a response and said, in
Yeah.
my view, we did not have the capacity
Yeah.
to execute.
Okay. Then 13, further to the effect, Transnet is required to ensure that there are no internal skills and resources available to it before procuring external consultants. The Transnet DOA framework also places an obligation on Transnet employees / business units to always obtain quotes on FX. That's foreign exchange,
That's for an extent.
right? Forward rates and liaise with Treasury trading desk that will verify the rates to ensure it is market related. The business units can only enter into the FX hedges with the supplier once the rates are accepted by the Treasury trading desk via email. Once the above approvals are obtained, the Treasury traders will provide sign-off on the rate acceptance. And then 14, the exclusion of Transnet Treasury in terms of CBD facilities was in contravention of. So what is your contention of what this means? Obviously, you are saying MNS has misapplied or misinterpreted the delegation of authority.
They've quoted the delegation of authority in 2.7.13 correctly.
Correctly.
Correct. So that is
Yeah.
what it says.
Yeah.
I can confirm that. In applying it in 2.7.14, they are incorrect.
The exclusion of Transnet Treasury in terms of CBD facility was in contravention of the guideline on cost containment measures and the DOA framework. The use of regiments should not have been approved without having obtained the Treasury traders' sign-off on the rate acceptance. Okay, just repeat what your point is, why you say they were wrong.
So, Mr. Chair, in terms of the, so they say the use of regiments should not have been approved without having obtained the Treasury traders' sign-off on the rate acceptance. So, Mr. Chair, in my view, they are dealing with two matters. Firstly, they are saying, and I don't know, they seem to be confused, the use of regiments should not have been approved. Okay, now I'm saying that the use of regiments should not have been approved, I'm assuming in terms of the cost containment measures, which I've given a response to. Without having obtained the Treasury traders' sign-off on the rates accepted. Now again, Mr. Chair, as I've said to you, regiments does not have the ability to approach the market. They have the ability to go and look at their screens and do whatever they do on Bloomberg because everyone has access to Bloomberg. But at the end of the day, it still comes back to the Transnet trading desk that has to issue the instruction to JP Morgan to say, please place this instrument in the market. JP Morgan will never issue an instruction on regiment. They will never accept an instruction from regiment. They have to accept an instruction from Transnet. And the only people that they would accept that instruction from is the trader. They wouldn't even accept the instruction from me, being the CFO, because I'm not the delegated counterparty to issue that instruction. So from that perspective, Mr. Chair, that for all appropriate times, the traders would have had to be involved in issuing the instruction to execute the hedge or execute the instrument.
Yes. So are you saying that although regiments was involved, ultimately there was no breach because before anything could happen, they would have to go back to Treasury.
Treasury was the only approved counterparty to engage, they were the approved counterparty with banks to basically issue instruments. And this paragraph that they've quoted, Mr. Chair, of 2.7.13, as I said, relates to business units, not to Treasury itself. Because remember, this instrument was being issued not on behalf of Transnet Freight Rail. There's no Transnet Freight Rail. Transnet Freight Rail is not a legal entity. Transnet was a legal entity. This loan was entered into between Transnet, the legal entity, and China Development Bank. Transnet Treasury would then be the authorized entity to enter into a cross-currency swap with a counterpart, which was JP Morgan in this case.
Mr. Mybeck?
Yes, thank you, Chairperson. So I want to deal now with another topic, and that is McKinsey Regiment's consultancy contracts on confinement, 4 in 4 days. So far we've been dealing with the 1064 transaction advisors contract and fundraising. There were other parts of the fundraising that you were not involved in, which occurred in the time of Mr. Garma, principally the ZAR club loan. Can I take you please to bundle 5B, page 499. Mr. Singh, sorry, it's your exhibit.
Oh, sorry.
5B.
This is a fact.
$499, eh?
Sorry, which page?
Yes,
Mr.
Chairperson.
Mybeck?
What page, sir?
499. If I can direct your attention, please. So this is a part of one of the money flow reports at 499. Let's direct your attention to paragraph 44, 5, and 6. You'll see at 44, 31 March 2014, Transnet decides to award the coal line contract. March 2014, Transnet decides to award the coal line contract to McKinsey and Regiments on a confinement basis without competitive bidding. Then 1 April 2014, the next day, Transnet decides to award the Kumba Iron Ore contract to McKinsey and Regiments on a confinement basis without competitive bidding. And then paragraph 46, on 3 April 2014, Transnet decides to award the manganese contract and the NMPP contract to McKinsey and Regiments on confinement without competitive bidding. Do you see that? So there are the 4 contracts in 4 days. You see that?
That.
So you accept that happened?
I recall that these contracts were,
Yes.
or these confinements did occur.
We'll come
The dates-
to some of them in a moment.
The dates I'm not too sure of, but I do confirm that they did occur.
I just want to take you, and it's something that we touched on yesterday. Could I ask you please to go to page 716,
Of the same fact.
same bundle, 716, so annexure to this report. What you see at 716, perhaps you could keep your finger there, and then turn back to page 700,
So I
You'll
keep
see-
my finger here and go back to 7.
so you'll see at 700 that this is a bid submitted in respect of the coal line. You see that?
That is correct.
Then if you go forward to 716, this was a bid submitted by McKinsey and Regiment's Capital jointly. And 716 says, we, that being Regiment's Capital, will subcontract consultants and services from a company advisory, Homex and Albertine, and provide them with skills development opportunity. You see that?
That is correct.
So when I mentioned to you that what happened in respect of these contracts is that Regiments actually used Homex and Albertine as supply development partners. Do you see that?
That is correct.
And these are the two main, or amongst the two main money laundering entities. You see that?
I see that, sir.
Did you ever read this bid?
Mr. Chair, as I explained previously, Mr. Chair, these, the confinements that Mr. Myberg referred to would be prepared by procurement based on the facts that's given by business. If they believe that the confinement rules apply in the business circumstances, they would then prepare the necessary confinement documentation that would then be approved and submitted through to myself and ultimately to be approved by Mr. Molefe. Once those documents are then approved, Mr. Chair, the confinement document is approved, it goes back to procurement. Procurement then basically sends out a request for proposal, a formal document. That formal document would then set out the business requirements and what is required from the potential service provider or the potential service providers. A cross-functional team would then before that, the RFP would then set out the return date and all of those requirements that needs to be fulfilled. The cross-functional evaluation team will be identified and they would sit and receive the bid or bids, as the case may be, and they will evaluate that bid against the business requirements that were issued in the RFP and the evaluation criteria that was set out. This particular document, Mr. Chair, would go to the procurement team or the evaluation team that would then evaluate that. I would not necessarily ordinarily receive an RFP document like that.
When you say not necessarily, what do you mean by that?
I have never, well, in this particular document, I did not receive.
All right. Well, let's go to just one other example. Go to page 721. Here you will see that it's the bid for the NMPP. Do you see that?
Yes.
And if you go forward then to page 732, you see the same text in respect of regiments. 732, third bullet point, your subcontract consultants and services from companies such as the company advisory, Homex and Albertine, and provide them with skills development opportunity. See that?
That is correct, sir.
Could I ask you please to turn back then to page 500? Says there at paragraph 49, McKinsey and Regiments prepare bids. We've gone through these. Coal line, Kumba iron ore, manganese and NMPP contracts with Transnet. Regiments indicates they will be using Albertine and Homex as its supply development partners. Albertine is Mudli's company. Homex is a Gupta laundering vehicle, which is ultimately paid more than 100 million of the value Regiments receives under these contracts. See that?
That is correct, sir. Mr. Chair, I think it's also appropriate to probably comment in terms of the evidence of Mr. Fine in response to this. I think did allude to the fact that I'm not sure if they actually did, McKinsey did reference checks or actually vetted Albertram and Homix in any way or form before allowing them to be supply development partners of McKinsey.
Just so that I understand, and perhaps you must correct me if I'm wrong, in relation to these 4 contracts, this is not Regiment's being McKinsey's supply development partner. It seems that they bid jointly in a partnership, effectively.
I don't think so. I think this was where they still were supply development partners to the regiment.
Right. So you understood the structure to be that Regiments was still, and I can have a look at that, was still McKinsey's supply development partner, and then Regiments itself had its supply development partners, as we've seen.
Or subcontracted a portion of the work to,
All right.
to whoever they needed to do it.
Could I now take you, please, for the first time, to Exhibit BB 2.1A?
Give me a second, so let me just...
And then could I ask you, please, to turn to page PSV 62.
There's lots of notes and stuff in this one, so I'm not too sure.
I don't know about that.
Seems like a working...
Chairperson, can we just get a bit of clarification exactly what this relates to? So, because we're sitting with electronic versions that we're trying to
It relates
find
to
our
these,
place.
It relates to these contracts.
Okay.
What contract?
The ones that we're just talking about now. The 4 on 4 days.
Yeah, this is Mr. Peter Volming's statement. I think that's what you're looking for.
So page 62. And I'm going to ask you to comment, I think, on 3 things, Mr. Singh.
Page 62, Exhibit BB 2.1A, if that helps you.
We don't have those bundles. Maybe if my learned friend can refer to a specific person, because I know we were given, as an example, affidavits, and we've saved it in that regard.
So it's Mr. Volmink, Peter Volmink. All right. Now, what Mr. Volmink says at page PSV 62, paragraph 138. Are you there, Mr. Singh?
138, I am.
Yeah. So he talks about over a period of 4 days, the previous GCE approved 4 confinements, and he sets them out. And at 139, he says, although each of the transactions viewed separately fell within the DOA for confinement given to the GCE up to 250 million, the combined value of the transactions fell within the DOA of the BADC at the time, up to but not exceeding $1 billion. He then states that given the fact that the transactions related to the same or similar services and were awarded to one firm within a few days of each other, Transnet effectively awarded one package of projects to McKinsey, valued at 619 million, that ought to have been taken to the ADC for confinement purposes. The applicable provision of the PPM warned against the practice of parceling. Under the heading Prohibited Practices, PPM 14.2.3 states the following, quote, when the full scope of work is known at a point in time, requirements may not be deliberately split into parts or items of lesser value in order to keep the transaction value within a particular delegation of authority level, or to keep it below the threshold of an AC or a person with higher delegation of authority. This is considered to be parceling and will be regarded in a serious light as it amounts to non-compliance with procedural requirements. And then he ends by stating that on the face of it, the splitting of the transactions amounted to a breach of the rules against parceling. I just give you an opportunity to comment on that.
Mr. Chair, firstly, in terms of our 10.6 response that we were required to respond to Mr. Volming's statement, we were not required to respond to this allegation that he makes. But in the interest of time and for us to move forward with this, Mr. Chair, I'm not completely familiar with the rules of parceling in terms of the PPM, as it's basically outlined here in terms of paragraph 14.2.3 of the PPM. But what I can say, Mr. Chair, is that, and I'm not an expert at procurement, and as I said before, these confinement documents would have served before procurement. Procurement would have probably been the people that actually prepared the document. I would assume that having it gone to Mr. Molefe and myself in terms of value, it would have been approved by at least Mr. Peter. I don't recall if he did or he didn't, but if we have the submission documents, we can confirm that. And Mr. Chair, in my view, I would suggest that this does not amount to parceling in that it may have been services that were provided by one firm, but the skill set that was required and the service that was required in each of these items were significantly and distinctly different. So if you take, for example, the NMPP contract. The NMPP contract, Mr. Chair, was a de-risking of a capital project. So it basically says capital project is in trouble. It's like a Medupi and Kusile. Its costs are going from, it started at 9, it was at that time, I think, 25, 26 billion. And we were behind schedule, and the costs were continuing to escalate. So the nature of that project, Mr. Chair, was basically to rescue the project and required very different skills compared to, let's say, a manganese construction contract. Now, the manganese construction contracts, Mr. Chair, as you will remember, when we were giving evidence regarding Mr. Bester, that contract, the manganese project, let's call it the manganese project, as it relates to McKinsey here, was advice on a contract that was still to be entered into to prevent what we had seen on the NMPP to recur. So again, it was very different deliverables. It was distinct deliverables. The iron ore contract, Mr. Chair, again, was a 20-year, if not 50-year contract, if not an evergreen contract that we had, I think, with Kumba Iron Ore and Asmang at the time, with an attempt to renegotiate that contract, to be able to get a higher revenue stream out of that contract for Transnet. So in that case, Mr. Chair, that was again a very different set of skills that was required. You needed to understand the iron ore industry, you needed to understand the capital requirements of a mine, you needed to understand the capital requirements of Transnet in terms of the iron ore line specifically. So it was very different skills. In terms of the coal line contract, Mr. Chair, that was also a very distinctly unique, different deliverable. In terms of the coal line contract, we needed to unlock the bottlenecks that the coal line was experiencing. And unlocking the bottlenecks meant that if we were doing, let's say, 75 million tons of coal through the iron ore line per annum, we needed to identify the bottlenecks, debottleneck the line to enable us to move from 77 to 70, from 75 million tons to 77 million tons per annum. So in my view, Mr. Chair, the distinct nature of each of the deliverables, in my view, does not allow it to be classified as parceling, albeit that it was probably issued to McKinsey as one firm. If we issued this out on open tender, Mr. Chair, it would have went to 3 or 4 different firms because of the different skill sets that are required to actually achieve the outcomes that we require.
Now, there's two other things that I just...
I wonder whether the test to establish whether a set of transactions, separate kind of transactions, constitute parceling would be whether there would be any problem if they were given to different bidders. Could they be done by different bidders?
So I don't know if you finished.
As I understand
Yes.
parceling, and you will tell me if I've misunderstood it, it's when one transaction is split up into different kind of transactions in codes in order to circumvent a certain limit on delegation of authority. Okay. Now that obviously maybe would be easier to see if you have one transaction maybe that has different components, so it could be given to one person in one go, but you decide to give it to the same entity as if it's different transactions, but actually it can be different components of the same thing.
Mr. Chair, I think, well, I'm not too sure what you're asking. I followed you until...
I'm just thinking if
Yes.
if you instead of saying I'm giving Mr. Singh this contract to build a bicycle,
Yes.
okay, instead of saying that, I say I'm giving Mr. Singh a contract to do a certain part of, or certain part or parts of the bicycle today. In a month's time, I give him a contract to do another part or other parts of a bicycle. That must be parceling, or would it not be?
I think, Mr. Chair, maybe let's use
It's
this.
like splitting.
It's like splitting, but maybe let's use this example. Let's say Transnet has a requirement for 1,000 books. Okay, so the buyer knows he requires 1,000 books, but he then says, "Okay, I place an order for 250 books in week 1. I put another order in week 2, another week in 3, another one in 4, to the same supplier.
Yeah.
But knowing that the 1,000 books would need to go to, let's say, the GCE for approval, but the 250 books can be approved by himself. So, crudely put, that is what parceling means.
Basically
Splitting something that would be
splitting
identical.
that should be one transaction.
That should be, yeah, but also it should be relatively identical to something that you would get.
Yeah.
So you can't say, let's say he had a requirement for 1,000 books, right? But black books. And then he needed 250 blue books. So when he places the order for 250 blue books, it's not necessarily that he's then splitting the order from 1,000 black books. So there has to be some link.
So you say there must be some identity
In my understanding, Mr. Chair, as I said,
yeah.
I'm not just expert in this aspect of the PPM or the PPM in
Yes.
general, but I'm saying there has to be some similarity for you to link.
And you say here because one is coal, another one is iron ore, another one is manganese and so on, you say it can't be.
Well, not by just the nature of coal, iron, or manganese and NMPP. I'm saying it could have been NMPP for all of them, but the nature of the output was significantly different. And the skill set that was required was significantly different. Mr. Chair, let's say, for example, if we sent the coal contract or the coal confinement to Mr. Malek, he may have said no. He said, no, send it out to open market. Right? And then you would have had 50 other suppliers coming and saying they could do this. So again, it comes back to the point of, is it splitting or is it not? It's not, because you could have had an independent procurement event
Yeah.
that led to the award for iron ore, manganese, or NMPP.
Okay. I guess Mr. Maybeck and counsel for Mr. Singh, us being lawyers, will think of splitting of charges. Yes, continue, Mr. Maybeck.
Thank you. So there are really three things that Mr. Formick dealt with. One was parceling. Secondly, he submits that the requirements for confinement weren't met in these instances. But thirdly, what he says, and it's the thing that I want to take you to in the interest of time, is the notion of confidential confinements. Could I ask you, please, to go to page 63, PSV 63. And we're dealing still, as you know, with these four contracts.
Yes, sir.
So there he has a heading, confidential confinements. If I could fast forward, let me take you to 147 over the page. It says there, however, for reasons of confidentiality, some of the McKinsey confinements, such as manganese, NMPP, and iron ore transactions, did not follow the normal review and sign-off process. This meant that the confinements were taken to the GCE for sign-off with little or no input from reviewing bodies. The next paragraph, the 2013 PPM states that, quote, in instances where confinement is confidential, the GCE may approve such confinement without the confinement request being routed via any other authority. This was based on a provision in the 2013 DOA framework that allowed for confidential confinements. And then at 49, he says there are a number of concerns with the manner in which confidentiality was invoked in the McKinsey confinements. And perhaps before we get there, let me show you one of these contracts. You go to Exhibit BB 2.1D. This is where you find them. They were all signed by you and Mr. Malefe, these four contracts. Or four confinements, rather. Now, Mr. Formink,
Sorry, what page is it?
well, let me just retrace my steps. He says that for reasons of confidentiality, some of the McKinsey contracts, such as manganese, NMPP, and iron ore, let me take you to the manganese contract, which you find, or sorry, I keep saying contract, confinement. You find at PSV 1299. So there you will see from yourself to Mr. Malefe, manganese execution support. And if you go to page 1305, you'll see that you compiled this. Excuse me, is that the 31st of March 2014?
That is correct. Sorry, that is correct.
31. And your recommendation, and all of these confinements are similar, all four. Your recommendation is recommended that the Group Chief Executive approve the resourcing strategy and remuneration model for the manganese execution by accelerating and optimizing, thereby supporting the initiative to mitigate the EBITDA at risk by mobilizing a team, and then sub 2, confining and awarding the service to support the internal team to McKinsey and Company and its BE consortium partners. Do you see that?
That is correct.
Now, the issue of confidentiality arises, if you have a look at page 1302, there's firstly a motivation for confinement itself. You see that? In the table.
Yes.
And then at paragraph 25, it says, additionally, due to the confidential nature of the information, the engagement cannot be subject to an open tender process. Because in terms of para 15.1.4c of the revised PMM, in instances where a confinement is confidential, the GCE may approve such confinement without it being routed via any other signatory. Do you see? So that's a reliance on that provision in the PPM. You see that?
That is correct.
So perhaps you can keep that open, Mr. Singh, and then let's go back to what Mr. Forming says in his affidavit. I could ask you to have a look at paragraph 149. I think I'd read you the first sentence at page 64. There are a number of concerns with the manner in which confidentiality was invoked in the McKinsey confinements. First, as already stated, multiple layers of review were bypassed as a result of invoking the confidentiality provision. Secondly, the confinement memos contain very little, if anything, that explains why the submissions were confidential. And then thirdly, in addition to invoking confidentiality as a reason not to route the confinement memos through the normal sign-off process, the submissions erroneously invoke confidentiality as a reason for confinement itself. And then 152, fourthly, in certain instances, the confinement memos made no claims to confidentiality. Well, we're not dealing with that now. But effectively what the complaint is by Mr. Forming is that this was a confidential confinement. It was really one layer. It was compiled by you, sent to Mr. Malefe, and he approved it. Now, what was confidential about these contracts?
Mr. Chair, as I said originally, I have not been privy to this part of Mr. Forming's affidavit. In terms of the 10.6, we're not required to respond to this paragraphs of Mr. Forming's affidavit. And Mr. Chair, in terms of the document at 1299, this as well, Mr. Chair, I have not seen this document before. So if I can have some time to be able to study this, I can possibly come back and give you some feedback.
Okay.
I mean, you will understand, of course, that you can be questioned about things that you weren't asked to put an affidavit on.
No, I agree.
But perhaps just so that, and I'm more than happy to afford you the time. I mean, it's a very important issue. Maybe what I can do is I can just show you where there are other, perhaps we can look at all four of these confinements,
yes.
and then over lunch or whenever you can have an opportunity to look at it. If you go to page 1283.
1283.
1283, yeah, you find the the coal contract or coal confinement. You'll see that it's at 1289, compiled by you, signed by Mr. Malefe. And you will see at 1287 that there's reference to the confidential nature of the information. Then if you go to 1291, is the Kumba contract. It's also compiled by you, signed by Mr. Malefe. And again, the confidentiality provision, you'll see on each occasion, Mr. Singh, after that table, then you get, in this instance, paragraph 22 at page 1295, the confidentiality provision is referred to. At 1299, you find the manganese contract, confinement, which I've taken you to. And then the fourth contract appears at 1307. This is the NMPP. Again, at 1313, compiled by you, signed by Mr. Malefe. And you'll see at paragraph 27 at 1311. Again, there's reference to the confidential nature of the information.
I've seen that.
And then perhaps what I could also do is just to assist you in this regard. If you have a look at page 1273, this is a different confinement relating to capital optimization. We're now not dealing with the McKinsey confinements, but if you have a look, if you turn then to 1280, you'll see it's another confinement, and here it goes through the various levels. Prepared by Mohammadi, recommended by Peter, recommended by you, recommended by Forming, and then ultimately approved by Malefe. The point made by Mr. Forming, in short, is that once one invokes confidential confinement, then the GCE is essentially entitled to authorize it himself, which is what happened in relation to these contracts.
That is correct.
So you'll have a look at that for us. I mean, there's simply one question really, and that is on what basis were these contracts confidential?
That is.
Okay. And then if I could take you back to paragraph, or to page 500 of bundle 5B.
So we done with Forming?
Yeah.
In black.
So I just want to point
Black-
out to you, paragraphs 51 and 52. So we know that these 4 contracts that were awarded to McKinsey regiments resulted in money laundering. There are 2 other contracts that you signed, which also resulted in that. The one was the SWAT 2 contract at paragraph 51, and then at 52, it says, on the same day, 24 March, Brian Malefe issues his recommendation for the GFB contract to be awarded to McKinsey and regiments on a confinement basis without competitive bidding. This is another contract which is later discovered to have been used by regiments to launder Transnet payments through Gupta laundry vehicles. Do you have any comment on that?
No, sir. I don't have any knowledge of these laundering activities, but I do remember that we did.
Sorry?
I said I don't have any knowledge of the issues relating to money laundering, but I do remember the SWAT 2 contract, and I do recall, I think, something relating to a GFB breakthrough project.
And perhaps I can just show you that GBF contract. If you go back to filming, BB 2.1D, and can you please turn to page 1315?
Did you say 5B?
BB 2.1D. At page 1315, that's where you find the so-called GBF confinement, this time not done on a confidential basis. You look at 1322, was compiled by Mr. Garmo, recommended by you, and then recommended by Mr. Malefe. Do you see that?
That is correct.
And it's addressed then to the BADC.
Yes.
Goes through various levels. Now, Mr. Singh, that brings me to the issue of invoice tracking. Could I ask you please to turn to page 698 of bundle 5B.
698. Six nine eight, no?
And so, you know, this is the second money flows report that you were provided.
We only, so from my knowledge, we only received a 3-3 notice relating to the McKinsey money flow stuff.
Yeah, well, this is what we're dealing with. We've got two. Well, you've seen this.
to check and confirm?
Okay, well, let me,
We can carry on.
I mean, I can take you back to the notice if you want, but as I recall, and you must tell me if I'm wrong, what happened here is the following. There are two reports in your exhibit. The one report is at 490. Do you see that? That's the one that we've been discussing, which sets out the 4 confinements in 4 days. You see that? Mr. Singh, you've looked through these. You've seen that report, correct? We've been dealing with it.
Chairperson, just for the record, is my learned friend saying that we got this per a 3-3 notice?
Well, I just want to confirm what the problem is here.
Yeah.
Just so that I'm just trying to take Mr. Singh to the reports and to just identify what the concern is. In the bundle, Mr. Singh, and we can come to the issue of 3-3, there are 2 money flow reports. You've seen that.
Yes.
Okay, so the one, and I'm not trying to quarrel with you, I just want to see if there are any issues.
No, carry on, sir.
The one you find at page, it starts at 490, and it's headed or titled, Report on Vickers Cigar's Relationship with Regiments. You see
Yes,
that?
sir. Yes.
Now that is the report that you and I have already dealt with in some detail already. For example, at 499, we've dealt with the 4 confinements. There are a lot of annexures to that report, as we've seen. It's got the RFPs, etc. The next report, and this first report on Vickers Cigar is dated the 14th of November. The next report is contained at page 694, the second report. This is dated the 13th of November. It's a report on the laundering of regiment's proceeds. You see that?
That is correct.
And that report too contains a series of annexures, I think goes all the way up to I think it's 768.
Yes.
Now, do I understand you to be saying that you never received you received the first report? Because remember, and while I may not be entirely familiar with the facts, these came from money flows, not from Transnet.
No, I'm familiar with this. Mr.
Okay,
you're
familiar
move on,
with
yes.
All right. So let's go to this second report. And I want to direct your attention to paragraphs 13 and 14 at page 698. Are you there?
I am, sir.
Okay. So what is stated here in this money flows report is that regiments maintained a running reconciliation of the payments it had received from Transnet and the corresponding payments it had made to ESSA's laundry entities and Albertine. Now, I mean, you're familiar with what's alleged by money flows. We needn't go back. I've put it to you many times that there was this arrangement between ESSA and regiments in terms of ESSA would get 50 cents in the rand, and Albertine, you might have read, got 5% in the form of Mr. Moodley. All right? So we can go back into the report, but if we needn't do so, we won't. So regiments maintained a running reconciliation of the payments it had received from Transnet and the corresponding payments it had made to ESSA's laundry entities and Albertine. The spreadsheet containing this reconciliation was named Advisory Invoice Tracking. The copy of the Advisory Invoice Tracking spreadsheet generated on 7 December 2015, in brackets Annexure 6, shows that these laundry payments included payments on every contract with McKinsey, and that in addition to the payments in the 2015-2016 financial year, just under another 90 million worth of laundry payments had been made in respect of regiment stroke McKinsey contracts in the 2014-15 year. Now, on the 7th of December 2015, by that time you had moved to Eskom.
That is correct.
All right. So I just want to take you then, and we're going to come back to paragraph 14. Can I just take you to this document at page 7, Annex A, which you find at page 760.
That's 760.
Well, it's Annexure 6 starts at 760, but it's rather unusefully DCJ a blank page, so it's 761, yes.
Okay.
So here's a series of spreadsheets. You've had an opportunity, presumably, to look at this, Mr. Singh?
Yeah, I did.
All right, so what one sees, and perhaps I'm just going to go to things that we're familiar with. I mean, we've spoken a lot in your evidence about the China Development Bank. So if you go and you run down the second last set of rows, you'll see there's the date 2 June, and you see project in the middle, China Development Bank. Do you see that?
What page are you on, sir?
I'm at page 761.
Yes.
And the second last set of rows. Another way to track it is to go down in the date of invoice to 2 June 2015, towards the bottom. Are you there? Date of invoice 2 June 2015, then there's an invoice number, and then there's the project, China Development Bank. There we see the 189 million that was paid. We've been through this. You see that 147 on the schedule was paid to Albertine. You see that?
Yes.
And I think I've told you that what happened to that money after that is 122 million was laundered to Sahara Computers. But this gives you a sense then, doesn't it? I mean, if you drop down a few lines, 1, 2, 3, there you see the NMPP contract we've been speaking about. You drop down 2 lines under that, you see the GBF breakthrough contract, which we've just discussed. You see that?
I do, sir.
All right. So if we go back then, please, to paragraph 14 at page 698. Regiments forwarded copies of the advisory invoice tracking spreadsheet to Anoj Singh when he was the CFO of Transnet. See, for example, Annex 7, email of Wood to Singh on 18 May 2015, and to his successor as Transnet CFO, Gary Peter. See, for example, Annex 8, email of Wood to Peter of 5 August 2015. Then they say the CFOs of Transnet were aware of the payments being made. By regiments to S's laundry entities. Now, can we have a look then at this Annex 7, which you find at 765. Are you there?
I am there, sir.
So it's 766. We start at the bottom. From Yvonne McCorney to Eric Wood on the 18th of May, 2015. Good day, Mr. Wood. Attached is the updated schedule. And then shortly after that, I think 2 minutes later, Mr. Wood forwards it to you. Subject revised outstanding revenue, attachments invoice tracking 2015-2016. Hi Anoj, I've attached the list of OS, I assume that's outstanding. You confirm that?
That is
Invoices as requested. You see that?
correct. That is correct.
Now, we have then provided you with the attachment. And that attachment, and in fact this email, appears in bundle 5C at page 1932. And your attachment is at 1924.
Please just repeat the bundle, Mr. Mahato.
This goes back to the B bundle.
5B,
5C.
5C.
Yeah.
Just repeat the page, 19 what?
Page 1923.
Sir.
All right. So the attachment, we provided you with a number of schedules comprising that attachment. They run from 1924 through to 1935. You see that?
That is correct.
Now, if you go to 1924, what's written at the top by one of the investigators is that when you open this document, this is the first view. And what you see here is, I think importantly in the third column, the invoice date. Then we have the project, and you have the amount. You see that? And it's indicated whether it's been paid or outstanding. You see that?
Yes.
Sorry, Chairperson, we
Yes,
can't
sir.
hear the
Sorry.
client.
Yes, we can.
So may I just ask for some advice?
Yeah.
All right. I'm sorry for the interruption, but I had asked because this is quite important for us all to be provided with color copies. I understand that you don't have color copies, DCJ, is that right?
Well, on page 1924 and 1925, I have colored portions of the tables.
I see you've got, or yours colour copies.
Well, one column is color. Well, it's color copy, yeah.
So I think
So in
I'm,
other words, unlike the one where we were
Yeah.
just now, which was colored all over, this one is just certain blocks that
no,
are
that may
colored.
be correct. I think I might be at a disadvantage because I don't have colour. So what's happened to mine, it's been photostated and then the colour obscures it. So I'm at a bit of a disadvantage. But DCJ, perhaps this is something, if I was given an opportunity, I can try and sort out at lunchtime.
Let's do
All right.
deal with it after lunch if you'd like.
No, I'll go through it now.
Oh, okay, all right.
So that's the first view. Mr. Singh, are you with me?
I'm with you, sir.
Then if you go to the second view, it says unhide columns G to J.
Hang on, I can see the first view, but I don't see where the second view is.
Okay,
I
well,
thought it would be the next page, but it's not written second view on the next page.
No, well, these things follow. It's number 3.
Oh,
Only because,
okay.
as I understand from the investigator, what he had in mind is that the email would be 1.
Yeah,
So,
okay. Okay, so the second view is at page 1925.
that's correct.
Okay.
So what you then do is one clicks on this Excel spreadsheet to unhide columns J to G. And then what happens is you see from the amount column, which one found at the first view, this then unlocks the 1, 2, 3, 4, 5, the six columns on the right-hand side. So it unlocks columns headed Chavita Homex, etc. Albertine, do you see that?
I see that.
So what this second view shows you, for example, is if you track down to 15 March, the number of invoices dated 15 March, we've got coal, NMPP that we've dealt with, and in fact even one of the SWAT contracts we've dealt with. You'll see the amount that's due, and then you will see Chavita or Homex. In all of those instances, it reflects that they're getting half of the fees. You see that?
Yes.
So let's take coal at 1,337,599. That 66,800 is 50% of that. And then you will see that Albertine is getting 5%. You see that? So 66,880 is 5% of 1,337,000. You see that?
I see that.
And so it goes on. And then the same, that's March, the same would happen in April. Then if one goes to the next view, where you unhide certain rows, all that this really does is then enables one to see what invoices have been paid. You see that? So in other words, the view before said bank date, that was absent. There was no information in the last column. But if you go to page 1926, you'll now see the right-hand column is populated. You see that?
Yes, sir.
Reflecting the bank date.
I see that.
You see that, Mr. Singh? Are you there?
Yes, I'm there.
So in other words, the difference between 1925 and 1926 is that the bank date, that far right-hand column is now populated.
I see that.
All right. And then there's a whole lot of other information that the investigator has marked 5, 6, 7, 8, 9, 10, 11, 12, and 13, none of which is of particular moment for present purposes. The three important views then are the first, second, and third view, pages 1925, 1924, 1925, and 1926. Now, to begin, can I ask you, did you receive this email from Mr. Wood on the 18th of May?
Mr. Chair, I don't recall the email, but I guess if it's arrived at my Transnet email address, I can say I've received.
And did you have occasion then to open the email? Can you remember that?
Mr. Chair, I don't recall whether I opened this invoice or not. I mean, this email.
So it says, if we had 1923, hi Anoj, I've attached the list of outstanding invoices as requested. Had you requested Mr. Wood to provide you with a list of outstanding invoices?
Mr. Chair, I think we'd need to explain a bit of background behind this. And in order for us to do that, Mr. Chair, I would ask that we go back to the previous file.
Before you do that, but will the answer ultimately be yes, you requested, or no, you didn't request, or you want to check something before you say
Well,
you
Mr.
did
Chair,
or you didn't?
I don't recall, as I said, this email or the circumstances behind this. I can only think that this would have been a invoice, or these were outstanding invoices, as you would see from the, as Mr. Wood's message says, outstanding invoices. And if you then go to the 1924, you will see it is list of outstanding invoices. And you will see that this mail has come to me in May, and it actually has December, January, March invoices reflected thereon. So these are long outstanding invoices. So my only view in terms of why this would have come to me was that these were long outstanding invoices that would need to have been in some way, shape or form settled. Or we would have need to investigate why have these things been long outstanding. Now, Mr. Chair, why I wanted to go to the other email. This email is actually the email to Mr. Peter in August. But it actually gives more clarity as to why this invoice actually, or these invoices came to us.
Okay, you may go there.
Thank you.
Mr. Chairman, I see it's almost exactly 1 o'clock. Is this not perhaps a
yes.
good time to break it? I'll then see if I can get myself some color copies in the interim.
Okay, all right. So you'll continue with that answer after lunch.
No
Mr.
problem.
Singh. We'll take the lunch break. We'll resume at 2:00.
Thank you.
Thank you.
We adjourn.